Detective Lieutenant Steve Murphy, Rockwood Police.
Okay, good morning. I'm going to need you to start your video. There you go. Raise your right hand. You're here for a signing on record. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do, Your Honor.
Okay, go ahead.
Your Honor, on February 22nd of 2025 at approximately 10:41 p.m., Officer Freddie Harshbarger, excuse me. Second, please. Sorry about that.
That's okay. I'm not making you nervous, am I?
No, I just swallowed the wrong thing.
I'm just kidding. Go ahead.
On duty in fully marked patrol car 13-3. He was running stationary radar on Hero Drive near I-75 within the city of Rockwood when he observed a 2024 black Mercedes-Benz C-Class with Michigan plate of E. Edward H. Henry K. King 0719. Going eastbound on Hero Drive that appeared to be going over the posted speed limit of 25 miles per hour. Officer Harshbarger activated his radar and obtained a reading of 45 miles per hour. Officer Harshbarger proceeded after the vehicle. When the vehicle got to the intersection of Huron Drive and 4th Street, the vehicle was in the left lane. The vehicle then made a right turn from the left lane onto southbound 4th Street. As traveling down southbound on 4th Street, the vehicle kept weaving outside of its lane of travel into the northbound lanes of 4th Street. Officer Harshbarger stopped the vehicle, and the driver identified herself with a Michigan driver's license as Crystal Nunnery. Officer Harshbarger was speaking with her, and while doing so, he could detect an odor of intoxicants coming from the vehicle. She had slurred speech, watery, bloodshot eyes. Officer Harshbarger asked where she was heading to, and she stated she was heading home. However, she was traveling south on 75 into Monroe County, going away from the city of Detroit where she lives. While Officer Harshbarger was speaking with her, she stated that she is a CPL holder. And Officer Harshbarger asked if she was carrying at that point, and she stated she was, and she had a gun, a Taurus, a G3 with serial number 1, K King A Adam 19259 handgun in her purse with a loaded 8-round 9mm magazine. Officer Harshbarger removed the gun from her purse and later secured it. Officer Harshbarger asked if she was consuming alcohol this evening. She stated she had consumed alcohol, and she also admitted that she's currently consuming alcohol while driving her vehicle. Officer Harshbarger observed a red Solo cup in the center cup holder of the vehicle. Ms. Nunnery stated that she was drinking Grey Goose. Officer Harshbarger asked her to step out of the vehicle to perform some field sobriety evaluations. While outside the vehicle, she was unsteady on her feet, and Officer Harshbarger could detect an over-intoxicants about her breath and person. Officer Harshbarger had her perform the field sobriety evaluations, the horizontal gaze nystagmus, one-legged stand, walk and turn, and she failed all 3 of those tests. Officer Harshbarger advised Ms. Nunnery of her PBT rights, and she refused to take the test. Ms. Nunnery was taken into custody and transported to Gibraltar Police Department. While at the Gibraltar Police Department, Officer Harshbarger advised Ms. Nunnery of her chemical test rates verbatim from the DI 177. She stated she would take the test. The results of the first test of 0.232% BAC. After taking that test, Ms. Nunnery immediately ran into the jail cell and started drinking water. So at that point, Officer Harshbarger stopped the breathalyzer, filled out a affidavit for search warrant and a search warrant for Ms. Nunnery's blood. Officer Harshbarger contacted the Honorable Judge Jennifer Coleman Hessen with 33rd District Court. Judge Hessen authorized and signed the search warrant. Ms. Nunnery was transported to Corwell, Trenton, where Molly Johnson, RN, drew 2 vials of blood from Ms. Nunnery's left arm. The blood was sealed in the Michigan State Police specimen kit. On 2/24/25, I mailed the Michigan State Police specimen kit to the Michigan State Police Crime Lab in Lansing. On 3/10/25, I received a laboratory report from forensic scientist Rachel Perez stating the results of Crystal Nunnery's blood is 0.209 grams of alcohol per 100 milliliters of blood. During the investigation, Your Honor, Officer Harshbarger checked through lean with Ms. Nunnery Did not have a CPL, and at the time, her CPL expired on 11/8 of 22, and that the gun was checked through lien also, and there was no record of the gun unregistered in the state of Michigan. I submitted a warrant to Wayne County Prosecutor's Office. You have a charging document in front of you.
Based on your sworn testimony, I find the crimes of CCW, super drunk, and OWI were committed. There's probable cause to believe the crimes were committed by the defendant. I'm going to authorize the issuance of the complaint warrant. I'll note you sign the complaint. The court is signing and dating the complaint and the warrant for the arrest of the defendant. Have a great day. Thank you.
Appreciate it.
Jeffrey David Inch, 23R513309A. All right, so you're charged with failure to attend your biweekly substance abuse disorder group at the Guidance Center between May 4th and 10th. Count 2, failure to submit to twice weekly chemical testing on May 24th. You have 3 prior technical violations. That means your probation could be revoked and you could be incarcerated on this case for up to 93 days in jail. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? You have the right to a lawyer. I'll be happy to provide you with one at public expense. Would you like one?
Yes, sir.
I'm entering a not guilty plea. We're going to have a revocation hearing today. I'm going to give you a lawyer. I'm going to enter a not guilty plea, as I said. You'll go speak with the lawyer, and then you'll come back in here and speak with me. Do you have any questions for me?
No.
Okay. As soon as you speak with the lawyer, I'll get you out of here. Thank you. People against Sharp. Faraz Cartez Sharp, 24G700688. Jeez. Good morning, sir. Your name?
Faraz Sharp.
All right, so supposed to be 100 bi-weekly starting August 19th. That was the initial. And then you want time to pay. When was this last payment due, Lisa? Can you tell me?
I believe it was June 1st. Let me check.
The next one's due June 1st?
It was $125 a month beginning June 1st.
Okay, good. So we're on a good track here. So he's actually coming in before the payment's due. Congratulations, Mr. Sharp. You're one of the few that follow the court's directive, and it's not that hard. I give you credit. When can you start paying?
Can I start June 15th? That's when my trial is. June 14th is my trial. So I'm gonna start after that.
June 14th is your trial.
Yes, sir.
You have a trial where again?
Taylor.
When?
Taylor.
What's that for?
A trespass. Listen.
I can't hear you. You got speak into the device there.
Oh, that's for a trespass.
So you want to pay $100 monthly starting June 15th? Is that what you're telling me?
Yes, sir.
How much does he owe, Lisa?
$705.
All right, so if I let you do that, that means it's going to take you 6 months to pay it off. I'm going to do that, but I'm going to say, but all money due by October the 10th, okay?
Okay, that's perfect. That's when my baby is due. That's perfect.
Well, congratulations, boy or girl. Do you know yet?
She just went to find out today, but we're having a gender reveal party. So.
Well, good luck. Good luck. Okay, so if you need another extension, let me know, okay?
Okay, thank you. And one more question. Can somebody send whatever else I have to do to my mail? Because I was in jail when I had everything, so nobody sent it to my address, like everything I had to do. And
Here's what I want you to do. Get a hold of your probation officer.
Okay.
Call your probation officer and tell them what you want, okay?
Okay. Thank you.
Yeah. All right. Good luck. Thanks.
Thank you.
Have anything else ready? Have you talked to your lawyers yet, gentlemen?
Yes.
Who's your lawyer?
Crawford.
All of you?
Chucky. Chucky.
How about you?
Crawford.
And have you, two talked to Mr. Crawford yet? You have two?
Yes.
Okay. You can tell him I'm ready whenever he is.
Okay.
I'll tell you what, I'll call him.
He's not in his office. I'm not sure where he's at. I dropped the file off. He's not in there. Or he wasn't in there.
Oh, there it is.
Hey, I'm ready for you whenever you are on those sentencings.
Okay, I'm on my way in right now, Judge.
Thank you. Morning, Mr. Shanky.
Good morning, Judge.
How are you?
Come on, Judge. Thank you. 2 sentences, case civil infraction.
A separate issue?
Doesn't have to do with your.
44 CR 2396 is called for Cedric Matthews. Cedric Matthews.
This is a plea. It's already said.
Thank you. Come forward, sir. You still got the bad pad?
Yes. I'm sorry. Yours isn't really guitar.
That's where the pad goes. That's a bad pad.
Doing the best I can.
Man, I'm feeling sorry for it.
But give it another chance.
What are we doing about getting the other stuff going? What? We had trouble with it all day yesterday.
Yeah, and this is a separate issue from what was going on yesterday.
A separate issue?
Doesn't have to do with your pad specifically. It's just old and tired and it needs a new.
You can't help but blame Sonny Eckert.
Mhm.
Most people do. I'm
At the house. All right. Cedric Matthews, sir. You're here with Don Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about November 17th, 2024 in Jefferson County, Texas, you committed the third-degree felony of assault on EMS personnel. Do you understand what you're charged with, sir? If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case. You would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $1,000. If you do well, it gets shortened to 1/3, 3 1/3. If I follow this agreement, you have no right of appeal. Do you understand? Also, this keeps your record clear as long as you do well. That's what you want, right?
Yes, sir. Does it have threat of duplication?
What do you say?
Deferred adjudication.
Yeah.
Yes.
I just said deferred is deferred, and you're saying it wrong. It's not deferred unadjudicated. It's deferred adjudication or unadjudicated,
Yes.
which means you would not be found guilty so long as you follow the terms and conditions of probation.
Yes, sir.
It's only been around for about 25 years or so, but in the old days, to get probation, you had to be convicted, then you were sentenced, and then your conviction was postponed. You didn't go to prison so long as you followed the terms, but you were convicted. This keeps your record clear as long as you do well. You get a second chance. You're going to make the most of it?
Yes, sir.
Good. If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Good.
Well, you're pleading guilty voluntarily. That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you what's marked here as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct? State's Exhibit 1 tendered into
No objection.
without objection admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. So you know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. This states, and I find beyond a reasonable doubt, true and correct. Was that so?
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report, please. Anything else to add? I'm going to follow this agreement and defer any finding of guilt, as those findings have been made here in States Exhibit number 1. Even though there's enough evidence to find you guilty, I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. You shall be fined $1,000. There will be a terms and conditions of probation, which I'm about to sign here, which are normal and customary for this type of offense. Make sure you follow this.
Yes, sir.
If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 10 years. And it would be all my discretion. Do you understand?
Yes, sir.
Also, there's something here. In addition, one of the things, and this is helpful, maybe anybody can use this, is called, you will complete an anger management program. It helps you in terms of when you lose composure, how to handle yourself to make responsible decisions so that you don't fly off the handle and then end up in court.
I'm at a unity on my way.
Oh, good. Good. Yeah, I'm familiar with them and I'm on the board. Yeah, but go see the probation office and do well. Okay, sir? Thank you. Well, this thing keeps going in and out, you know. It'll come up and then this disappears. A case 24CR2313 James Ann Jail. There's a motion to dismiss in that case. Is there a plea in that, or is it just the dismissal? Okay. Restitution has been paid on that. Very good. This case is dismissed if Mr. Angel is here. That's you? Just dismissed it.
Right.
Does he need to pick up anything or he can go? All right. Hasta luego. Go do good things. That's a word to the wise for everybody. It's when there's a loss and a defendant is responsible for a loss, restitution, you pay restitution back, you get rewarded by me. As long as you can do it timely, because it doesn't do any good if it takes you 100 years. That doesn't help the victim. But paying the loss back fixes financially to a large degree. That helps defendants too in resolving their cases less seriously than it would be otherwise. Isaiah Mochison, 25CR428. What are we doing on this? Why?
It's a case that I discussed with you.
And Your Honor,
Something.
I advise Mr. Dusler, the defendant's brother is also in jail for murder, and this tampering arises out of that murder. The defendant was on a jail call on April 17th while on bond, and he's on three-way call with his brother who's in jail, as well as his sister, Amaya Moore. And he's asking his sister for
Who's he?
the defendant. He's asking his sister for some weed, money for some weed. We would just ask for a drug patch. We would ask for that he be tested today, as well as when he was in jail, he stated that he would.
The defendant?
Yes, Your Honor. He stated that he would kill an individual by the name of Peanut if he doesn't bond him out. While he was on the phone with his sister and Maya Moore, he also stated that he would cut off his ankle monitor if you put him on home confinement. I don't believe he's on home confinement, but I would request that he be on there, and I believe he does have a GPS monitor.
Do you?
Yes, sir.
Where is it on it? On your ankle?
I'm all right.
Well, what's he talking about? I mean, we're listening in to phone calls. It's what foolish person, when you call, it states, I believe it warns you could be recorded. And we do. All of them. How foolish can you be by saying things like that are going to get you in trouble now, in worse trouble? You're looking at up to 10 years in prison for this. And all of that you're talking about, all of that can come in at the trial. That can be admitted. You think a jury's going to find that amusing? Yeah, they wouldn't take a minute to find you guilty. Well, that's what you backed yourself into by foolish behavior. You're not the only one, but that's what gets you into jail or prison, acting foolish. All right. What's his bond right now? You're not walking out of here from what I've just heard. Your bond's going to get raised. You're going to get tested. You're going to jail. Then y'all can celebrate together if that's what you're going to do with whoever it is. But that's what your choices have gotten you to.
$25,000.
Yeah, that's not enough for that kind of behavior. Have a seat. Get a third chair on prison. Deal with you later. All right, next is Brandon Foray. He just went to the restroom. You can sit down, thank you.
He is here. I've spoken to him.
And he's kind of on the mail. You heard him yell out and scream all the time. He doesn't matter when you're a psychopath. After he settled, just settled everything. That's why I was trying to catch him. He's trying to talk to a small jury. That's why he was trying to get him out. Just let you know. Yeah, shoot. No, we read that. That's right. Where's
I have.
What are we going to do on this? Is that him?
Yes, that's it.
Come on up. What are we doing on this?
It's my first time meeting him, Judge. I have formal discovery that I'm still waiting on my tape request to be fulfilled.
What kind of things is what we do here? This is admitted to trying to help dispose of these many places as possible. See, that's this case of bagging all the things to I don't like it. Okay, sure. But help us all to do that. This is a working order.
First time meeting him.
How much time? You guys, 4 weeks, get a resetting, so 4 weeks. Edgar Hernandez.
Thank you.
Edgar Hernandez is called next. In cause number 25 CR 188, there is no answer in the courtroom. I asked the bailiffs to call into the hall for Edgar Hernandez. What's his phone, please?
$1,000 cash. It's his last name.
No response to that name being called in the hall. No response to the name called here in the courtroom. Defendant has failed to appear. Warrant shall be issued for his arrest. His $5,000 bond is revoked. It is now doubled to $10,000. Plus, he must have a GPS device as a condition of bond, so we know where he is when he's not in court when he's supposed to be. Escar Herrera.
He is here, and so is Erica Bird.
Edgar Herrera.
Så inte jag spela.
What?
25 CR 122 is called Edgar Herrera. He doesn't speak English.
No, sir.
And please tell us your name for the record.
Erica Burgess.
And Ms. Burge, I understand you're going to translate today. You are fluent in English and Spanish.
Right.
Have you been a translator before in court cases?
Yes, sir.
Okay. And raise your right hand. Do you solemnly swear or affirm that you will truly and accurately translate from Spanish to English, English to Spanish during this hearing, which is Mr. Herrera's language? He speaks Spanish, and make sure that the translations are done correct so that we can have for the record the English translations and that it is clear and accurate. Will you do that? So help you God.
Yes, sir.
Lower your hand. And you are charged with the 3rd-degree felony of evading arrest or detention with a motor vehicle, which carries with it up to 10 years in prison. Serious. Do you understand? Ms. Minaldi is your attorney. Very good lawyer. Listen to her. She gives good advice. What are we going to do then?
Judge, we were actually here for a designation today. Last time he expressed that he was going to hire an attorney. He is now expressing that he is unable to do so since he lost.
Are you able to hire a lawyer?
Not right now. I lost my brother this week. They called me for
What-
the job.
What were you doing?
Just have I seen one video? Worked in the refinery.
How much were you making an hour?
Estaba a la hora. 22.
22. That's $40,000 a month plus. That's a lot of money. Are you a citizen of the United States? Are you a citizen of the United States?
Yes.
You don't speak English?
No habla inglés? No.
You have to be able to speak some English to be a citizen,
Ciudadano.
to pass the citizenship test.
Ciudadano.
How did you do that?
Mande. I was born here in Baytown.
Okay, but you were born here. You don't know English? Surely you have to be able to speak it. In the refinery, at the refinery, for safety reasons, you have to be able to speak English in an emergency, correct? How long have you been living in the United States? You were born here.
When I was small, they brought me back to Mexico.
Okay. Well, it comes in handy in America to speak English. Okay. Oh. What do you mean? Yeah, these things are always. There looks like an affidavit of indigence that was prepared somewhat. It's signed.
Judge, we did one last time, but we didn't have a translator available, so he wasn't able to fully fill it out. I have given him a new one today so that he can really fill it out. And Miss Burge has helped him with that.
All right. What do you want to do next?
I can have a forward reset on him to make sure that he can review his discovery and we can.
Okay, what's the offer on this one? This one now.
Probation offer, Judge.
That sounds promising. The birds.
Yes, sir.
Move on. Move on. Let's move forward. We're going to reset this for 4 weeks. Listen to your attorney. She's very smart lady. You have that. Hold on, everybody. Settle down. Do you have the indigence affidavit done? Okay, make sure that's done. Thank you. Get a resetting. Ryan McGowan, come on up. 25 CR 333.
Yeah, I think they're actually.
What is that? Indigent? Are you filling it out? Is it done?
Yes, sir.
Let me see it.
He has not been sworn to it. I will see that.
Well, I'll swear. You solemnly swear or affirm the contents of this affidavit of indigence that we prepared is true and accurate, so help you God.
Yes, sir.
Over your seat.
Great. Take care.
And court's going to declare you indigent, and that'll be filed, made a part of the record. What are we going to do?
I need a 4-week reset, Judge. I'm still waiting on my tape request.
You got it?
Thank you, Judge.
Reset 4 weeks.
Yes.
Dewan Walker.
Dewan
Walker.
Yes. This one's been lingering for a while.
22-40934. Oh, God bless. Yes. What are we doing? It's a state jail felony. What are we doing on this?
I have an offer, but I don't have any videos. I haven't been able to relate to them because this is my first.
What's taking so long on this? It's 3 years, going on 3 years.
I showed him at an initial appearance back in
What do you-
February 23. And he tested
What is your
positive
address
in
right
April.
now?
My address, 1464 County Road.
That's where that's the problem out there. I have you at 3044 in Oakland. Yeah.
And Judge, at one point he did forfeit a bond, so.
Well, that didn't help you, did it? That cost you some money.
Yes, sir.
What's your address?
1464
Hold on. 14 what?
1464
Okay.
County Road, 5102. Cleveland, Texas. 77327.
Zip again, 77327.
Yes, sir.
With that corrected on the face of the indictment. What are you asking for us?
I still need to get videos related to the case.
Can 4 weeks be enough?
Yes.
For everything? Thank you.
Thank you.
Good deal. Hi, Cooley. John West.
Well, and only for West City, so like this one.
You're Ty Cooley. Have you talked to your attorney?
I'm sorry.
He's going to be here. He's in another court. He's going to be here shortly. Okay. Thank you. Gotcha.
Put your right hand.
Sterling Booker.
Hey, Judge, good morning.
Here, on how I can.
Okay.
Judge.
Judge,
Yeah, Sterling Booker. I need the announcements. Yeah, 24 CR 23-2. Sterling Booker. That's you?
I'm sorry.
Mm,
Judge, I spent about 2 hours looking at my office yesterday, just watching videos. I think when the state get a chance to look at videos in this case, that I'm probably dismissed this case. And might look at some of the police officers in this case, particularly Bozeman, and his actions. My client was charged with assault on a police officer, particularly throwing elbows. I watched the video from the camera. That didn't exist. And when you look at the behavior of some of these officers, and I got the video, Judge, we can watch it with the prosecutor. I mean, it is not good. I mean, most.
All right, what do you want to do to them? I mean, it's not
right.
time for argument.
Well, no, I wouldn't. I mean, it was just so bad when he said he didn't care that she was pregnant. When they let her know that she was pregnant, I don't even care that you're pregnant. I mean, Bozeman was that bad. But what I want to do,
but nonetheless, words aren't enough to cause an assault. That's not a defense. Words are not a defense to an assault. And it says by striking about the head and body with her hands. I mean, did you see that happen?
I watched. Yes, what I did. Okay. Yes, so I watched the angle from the car, looking at them, and you don't see strikes to the head or anything. And when the state get a chance to look at this video, I think that they're gonna come to the same conclusion. And it might end up being a dismissal, Judge.
Okay, but right now it's an announcement. What do you want to do?
What I would ask you to do is to give the state time to look at all angles of the video, and I can show the one I'm particularly talking about. Put it on another announcement, and if Miss Sarah agrees with me, I think she'll dismiss it, yes. But I can do it right now.
30 days, Your Honor.
Okay, 4 weeks.
That'll work.
Roisha Diaz.
That case is here, Judge, and I talked to Mr. Sonny, that's gonna be dismissed today.
We sent her to the bank to get the restitution.
Did you get it?
It's coming up right now.
Okay, when it's done, send it to me. We'll dismiss it.
That'll be
Okay,
dismissed today.
TBD.
Thank you.
You're right. Brian Smith, Langston. We're still on.
Oh, sorry.
Yeah, Brian Smith.
I called his name several times, no one answered.
24 CR 840 is calling some cases.
I think he has a warrant though, about it.
Brian Smith, there is no answer in the courtroom. I asked the bailiff to call into the hall for Brian Jeffrey Smith.
Yeah, Judge, I think he has a warrant, so.
Well, if he's here, that'll take care of that.
I called.
What's his bond please right now?
Oh, he's Judge. I got a call yesterday from a jailer in Arkansas. He's incarcerated in Arkansas right now.
Okay. For what?
It was I think it was a couple of misdemeanor offenses, including a terroristic threat.
When were those? Do you know anything about when those were committed?
No, but I think they would have.
Bond.
Right, I believe he would have been on your bond when at the time. Right. Either way, he's going to fail to appear today. So,
What's his bond about?
And I think he has a warrant out of our court anyway right now. Okay, that's what it is. So he might as well accrue time for, and then you can deal with the bond issue and get him. Okay.
Is there a bond attached to it?
It's an AFRS warrant.
Okay, so there's no bond on it. Okay. I don't think we need to do anything.
No,
else.
sir.
Okay.
Wait,
Sorry.
back and talk enough that he.
All right, Rodney Broussard is next. Dustin? Yeah, I'm on. Where's Rodney Broussard? Is Mr. Broussard around?
He's in custody, Your Honor.
Yes. Anybody send Dustin?
He's got it again.
Richard Cook. Richard Daniel Cook, is he in custody too? Richard Cook? There's no answer. He's not in. Richard Cook. Richard Cook, 22-39655, no answer in the courtroom. I asked the bailiff to call into the hall for Richard Cook. What's his bond? Thank you.
There is no response, Your Honor.
There's no response to that name called in the courtroom. No response to the name called into the hall. Defendant has failed to appear. Warrant shall be issued for his arrest.
$15,000.
Bond is revoked. 15,000 is now $30,000 plus he must have a GPS device. Rodney Broussard. He's in custody.
Can we pass on that?
No. What are we gonna do?
Well, I need to go back there and talk to him. I hadn't had a chance to talk to him. Just to make sure we're on the same page. But that's a bond issue, so.
No, we got a motion to revoke probation announcement,
That's
right? I mean, we gotta dispose of cases.
This is the probation.
And the probation officer is here. The next,
I think the state's recommendation is after talking to the probation officer.
Yeah.
What we'd like to do is he's been in jail for 80 days. He had been in a different parish when he wasn't reporting. After he got out of jail, he still did not report. So what we would like to do is do a 60-day jail sanction. He's already served it and then have him do safe P as part of probation.
what's the other two cases all about? Oh, these are all in PRP?
TRPs, they're all together.
That's correct.
All right. Why don't y'all see if that's the way to do it? That helps him and we can move these three, get them moved. Okay.
So that.
DeMarcus Jones, while we're here.
Marcus Jones, the president, courtroom judge.
Mr. Jones, come on out.
Have not had an
Marcus
opportunity,
Jones, please.
not had an opportunity to review all of the discoveries, so we're asking for other names. It's a fairly good case.
What did Mr. Boulahanas have, Lisa? I saw him poke his head in. I didn't know.
He's with the prosecutor. He's got a new case.
Okay.
Wait.
Don't let me forget. I want to get these sentences done.
Okay.
Tell him half an hour. We'll call him. I don't know whether I want to start off with Mr. Blisman or not. Thomas Robert Blisman, 25W706462 FD.
Good morning, Your Honor. Mr. Chairman, can we get my client approaches?
So this is not going to be an easy one. Your name, sir?
Thomas Wilson.
All right, so he's done well on the bond phase. I took his plea to OWI 2 and to drive while suspend 1. And that was on April the 22nd. So I want to read the plea agreement into the record again, if I can, if you'll give me a minute. And everybody sign this, and here's what it says. Defendant will enter pleas to OWI 2nd and an added count of driving on a suspended. Sentence recommendation of 60 to 90 days jail is determined by the judge with work release if eligible and available. This jail condition may be waived at the discretion of the court if the defendant completes a specialty court program pursuant to statute. The OWI 3 charges will be dismissed at sentencing, provided the terms of the agreement are satisfied. A sentence of agreement of 2 years probation with sobriety, drug veterans, or mental health court that the defendant will need to find placement on or before sentencing. No early termination to probation. Any SCAO approved sobriety or specialty court will be acceptable. The 33rd District Court has an acceptable program. That's nice of them to tell me that. In addition, all the terms set by the court, costs of prosecution of a minimum of $500 or more is determined in alcohol, drug screening, and treatment, full restitution for any out-of-pocket costs for damages or harm incurred because of the offense on or before sentencing, if applicable. So I want to make sure, do we have the vehicle owner here that should have been notified? If you just give me 1 second here. We did send a letter to Gary Ennis Jr. on April the 22nd and also to Jason Glenn. This was a parked car, right? Is this not a parked car, or am I confusing this one? I'm just asking you. Can you tell me, Mr. Shemke?
Car was parked, I believe.
Yeah, I'm just curious as to why they notified 2 separate owners. Let me just double check something. Yeah, Unit 2, that's you. Was traveling northbound. I'm sorry, Unit 1 struck, that's you. Unit 3, which was parked on the street. I don't know why they, at any rate, I don't need to deal with that. I'm concerned he's got 3 priors. Granted, none of them have happened in the last 24 years. I'll give him that, 25 years, but still it's a 4th offense. I'll listen to anything you have to say, and we'll go from there.
Yes, sir. In the circumstance, I'd like you to reflect that he has done extremely well on bond. He has a strong family support system. He has remained gainfully employed. Judge, he had used poor judgment. He was trying to assist a friend, and he found himself in this predicament. But I will say, as far as the client goes, any instructions that I give him, he's always been able to follow them without any sort of issue. He's already been in treatment. Any sort of request or order that's been put in place by the court, my client has not hesitated to comply with 100% accuracy. It's because of that, Judge, and how well he's done on bond and the strides he's made with his life in the past few years, besides having this notation. I'd ask for jail to be waived at this time, honestly, to consider if there were to be a violation, but he's very eager to demonstrate full compliance with the sobriety court. He appears timely, very respectful, and I think that he's going to demonstrate an outstanding effort in the program, Your Honor.
Anything you'd like to say?
Yes, I just, I know I made a
bad mistake, bad judgment. But looking forward, I want to just, get this behind me, and I'll do whatever I have to do to make things right.
I don't know if I've ever had a fourth offender that I didn't send to jail, to be honest with you, on a drunk drive. I can't think of one. It's possible, but I don't know that I have. 2 years probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume those. You're not to go to any place where alcohol is sold or dispensed. You're to submit to chemical testing, PBTs, and ETGs when probation tells you to, when you know how often you have to test. You're to submit the PBTs, ETGs, and chemical testing on demand of probation. Like I said, you're to complete 60 days more on the SoberLink device from this date. But we will get that turned around. It'll be now covered by our grant. You're to attend 12-step meetings 3 times per week and provide written proof of attendance. You're to obtain an AANA 12-step sponsor. You're to attend all substance abuse treatment at an approved facility and provide written proof. You're to attend the Victims Impact Panel. You're to attend and complete the Earned Specialty Program. You're to report to sobriety court status review hearings with me every 2 weeks. You're to obtain and maintain employment and provide us with proof. Now, I'm going to talk about the fines. There was an agreement of $500, so I'm going to honor that. 200 fines, 500 costs, 75 victims' rights fee, $50 justice assessment, 8 1/4. Screening fee is 60 for 885. Probation fees are 480, bringing the total to 1365. Sobriety court probation fees, sobriety court fees are 360, bringing your total to $1,725. I'm coming back to that. You do have to pay, and I feel badly about this, but there's only so much I can do. Cost of recovery on this case is $150. So your total's $1,875. Now, I don't know what to do with you, Mr. Blisman. I don't usually come out here and say that. I don't. I mean, there's times I don't know exactly which direction I want to go, but just give me a minute, please. gonna do this one a little different. I'm gonna give you 200 fines, cost 500, that's per the agreement. $75 victim's rights fee, $50 justice assessment fee. $60 screening fee, $480 in probation fees, $360 in sobriety court fees. There's cost of recovery of $150. I'm going to order that you serve 90 days jail, and that will be deferred. You're going to serve I'm giving you credit for 1 day served. You're to serve 6 days on the court work program and pay $210 for that. That's your first 6 plus the 1 day credit. You're going to complete 4 days of community service. I'm going to give you all the way until September 1st to complete that. That's 32 hours. We're going to have review hearing dates. And by the way, your total now fines and costs, including the court work program fees, you know, with the $500 minimum cost, I don't know why they're putting that in there, but I'm going to honor it. It's $2,085, and I feel terrible about that, but I can't really do any better. I mean, these are all fees that are associated with the program. So it's 11 days jail now. Credit 1, serve 6 on the court work, 4 days community service. I'm giving you until September 1 to complete your community service. 79 days are deferred. You're to appear for a review hearing date. Lisa, I want you to give them a review hearing date every 4 months for me to determine if the defendant should have to serve the jail then. And here's the bottom line. You do everything. You cross all your T's. You dot all your I's. I'm not going to end up sending you to jail on this, and that's significant. I know that the other ones are old, but you still have 4 of these. Now, the last one was 20 years ago or so, whatever I said, but I'm going to do that. But, I mean, I'm giving you credit. You're doing well so far. I'm glad to see that they're not hamstringing me on these probation sobriety court cases. They're, you know, some could criticize. That's okay. But if you violate 365, and I'm telling you, I will give you the 365 days if you don't make it through the program. But I hope your goal here is not to make it through the program, it's to gain lifelong sobriety. Restitution, if any, will be handled through civil litigation. None of the names I mentioned are here, correct, Lisa?
I have a Motorola that just popped in that I can't identify.
Well, let's bring them in and or her in, whoever it is, and I'll ask them. How's that? So I'm going to do this for you, Mr. Plisman. Not that you don't deserve it, but it has been a long time, and we do make mistakes, and you've shown that you're, to me at least, that you're accepting responsibility, you're remorseful, you've done what we've asked you to do. So I'm going to be more reasonable here, or reasonable at least than I should be. Let's put it that way. Motorola, can you tell us your name, please? You have to show up with your name on there, please. What's your name? Motorola Moto G Power 55G 2023. What's your name? Start your video and tell me your name, please. Motorola G. Moto, if you better call, I don't know your name, sir, and you have to use, or ma'am, what's your name?
Judge, that's Stephen Bailey.
Okay, good
Yeah,
enough.
we're good.
So that's what we're doing. Can you pay all this today, or do you need time? How much do you have today? Okay.
Judge, I think there's a count too also.
Yeah, I know. I got to go on to that. You pay $1,000 on this, and then the balance, I'm just going to let you pay at the rate of $100 bi-weekly. Can you do that?
Yes, sure.
Pay that $100 bi-weekly. We'll start that. I'll give you some little bit of leeway time. 6/13/20 is the 27th of Friday, right, Lisa? Of June?
Yes.
Okay, so that's what we'll do on that one. I don't really have a register. Give me the other file. I'm gonna go light on, or I just need another page of a register. for count 2, like a first page. I'm just gonna fine you on that. I'll go light. 50 fines, 50 costs, 75 victim's rights fee, $50 justice assessment, 2 1/4, or 90 days, okay? Okay, sir. So here's what I'll do. Do you think that you can pay this, say before your first payment's due on the drunk driving?
Yeah, I pay this.
I'll tell you what, let's just do this. I'm gonna make it easier. All right. On the drunk driving charge, we're only going to have you pay $775 now, okay? So that'll be $775 on that case, and you're also gonna pay the suspense, so you pay both. Pay $775, you pay the suspend charge of $225, and then you pay $775 on the drunk driving, OWI 2, and then you just stick with that payment plan of $100 bi-weekly starting June 27th. Again, no problem if you need more time. I'll be glad to give it to you. You'll meet with probation. They might not need to talk to you, but since we had status reviews this morning, okay? I wish you well. Stay with me on this, please. Good luck.
Did you say review dates every 4 months?
Correct, and I'm gonna let you just set those up. with
Okay.
them. Yeah. Okay, thanks. Thanks. Sylvana, Barry, you're all set. 25W838569. Does he have a lawyer?
I'm sorry?
Does this defendant have a lawyer?
Yes, Your Honor. Christopher Shenke appearing on behalf of Attorney Record Christopher Lane. I do have the authority to stand in.
Did he call here and ask for a lawyer to stand in?
Well, Mr. Lane, he's a close friend of mine. I saw his name on there. I called him and I said I'd be happy to assist. So if he was happy to zoom in. I thought I was just trying to help.
Okay, good enough, good enough. To the charge, and you're authorized in that plea to the charge of impeding traffic,
I am
responsible or not responsible?
responsible, Judge.
Plea is accepted, original charge dismissed. I see they need a week to pay. 180 is the total, and I'm gonna have them paid by June, we'll just give it till June the 10th, okay?
Thank you,
June the 10th, thanks. Darnell Clark, Darnell Benjamin Clark, 25W376868.
Good morning, Your Honor. Christopher Shenke, can I get my client approaches stands trying to get one.
How you doing, Mr. Clark? Your name?
Next, we have Cody.
Sign reciting.
Oh, hold on one second.
You gotta sign something, man. Cody Nails. Cody,
Sign right there.
give me a bunch of them. You know.
Okay.
Right here, bud. Oh, but. Let's see my face down like there.
25 CR 84. What are we doing on Cody Nails? This is a DWI. Right. These things never go to trial. This get moved, but when are we gonna move?
Have a DWI third. I've received discovery at this time. If you're gonna give us 30 days, I'll be sitting down with my client next week to review the discovery. And I'll have.
Who's the attorney on this one, Steve? Mr.
Sonny, it's your case.
Anything you want to bring up on this?
It's Mr. Nell, DWI third.
Let's. Got a prior robbery conviction here on paragraph 3 that enhances it.
I do understand you.
Okay. All right, 4 weeks. You're good with others. Thanks. Okay, get a reset. Bruce, Crystal Vaughn.
I'm working on the paperwork of it.
Thank you. Dustin Jones. And it's Dustin Jones.
That's a plea. You did the paperwork on that.
Great. Kendrick Leday. You're gonna get a gold star here. Kendrick Leday.
Where you going?
Looks like a bond hearing question mark.
No, we've already done that. That didn't fit on the docket.
Okay, we're gonna. That's what we want to do, right?
Yes, sir.
Stage.
Yes, sir.
Kendrick Leday set on the bond, set on trial docket.
Yes, sir.
Okay, we've set for trial. Keith Pruitt.
Keith Pruitt, Judge, he's been declared, he's still incompetent. He needs to sign order. Sending him back.
And Wright Scott.
Yeah, that's, we're asking permission to get him more time, we're requesting retrial version.
Is 4 weeks good?
That'd be fine.
4 weeks on Brighton Scott, done, get a resetting. Keith Pruitt, let's go.
Right. That's the.
What's any mystery of days file?
Here.
Oh, sorry. Here, Bruce.
Okay, on Keith Pruitt, do I need to defend it out here, Bruce?
Yes, sir.
Do we need to defend it? There's.
Probably.
Judge, I don't think he's here. If it's recommitment.
It's a recommitment,
Yeah, he's probably still in the
the
hospital.
paperwork shows, Judge, that that they declared him mentally competent, and there's an order to file.
Stand on.
Let me look, this docket shows him on, has to be done.
All right, I've got.
This is the order. I don't know if you have that.
What's the date on it?
That was filed April 28th. It's an agreed order.
Nope, I'm not done. Hold on. Hold on.
It already has its signature on.
Where are you?
There was no problem here on this.
Let me go get Kim Judge, so.
Yeah, there's nothing in there like.
Yeah, I don't know anything about that file.
Stand by. Look at it, but. I don't have this in the file for some reason. And it's already been stamped. See, I think this was automatically signed by me, entered April 28th of 2025 for an additional 60 days. So it goes with 60 days from this date. So really, June 28th, 27 is when we need to be back on this.
That'll be fine.
Kim's gonna come.
Sure you can receive some more paper.
But I don't have, Mr. Smith gave this to me. That's nothing like this is in the file. That is, I've gotten, that signed, but you see it stamped, received on that date. He's set for a hearing today, but I don't need a hearing. Like, I signed that. I need a hearing in June when the 60 days are up.
Yes.
All right, that's when we need to reset it.
And I'm
June
sorry.
27th.
I put everything in the computer, but yeah.
Yeah, there's nothing in here. All that, he was talking about that. That's his. I don't have that. I need a copy from my file.
I'll get it for you.
What's day? What's June 26th or June 27th, day of the week, please?
June 26th is a Thursday, June 27th is a Friday.
What's the date on that? Right there, that's-
428.
I'm sorry, the date, it's, I'm dating it April 28th. Okay, I need it on the 26th. June 26th, that was only for 60 days, so. Yeah. Well,
Make
date,
sure it's in.
okay, reset for June 26th.
Oh, that's your copy. I'm good.
Thanks, Bruce.
You're trying to clarify.
I think.
Okay, Crystal Vaughn
Yeah, I'm working on the paperwork.
and Dustin Jones.
Just jumping ready for a plea.
All right, listen, Dustin Jones, please.
Yeah, we haven't called her yet, though. But she used. I don't know, we haven't called her. No, she's online. And Judge, I need Ryan Scott to come up and sign a resetting.
Wyden Scott, where are you? Come on up.
And who's the lead, Bruce? Dustin Jones, you said?
Dustin Jones,
Okay, I'll just, the fingerprint.
you need to be fingerprinted. We're gonna do a plea here.
Yes, sir.
Here, go in front of that nice lady. Thank you.
All right.
First. Mr. Jones. Mr. Jones, please raise your right hand. Do you swear or affirm that you will prove and implement yourself, you guys? Okay. You have to place it flat right there. You can open your mouth.
Let's sit on myself towards the rate.
And you go over to check.
24C01326 is called the state of first and Jones. Mr. Smith is your attorney, correct? Where'd he go? There he is. You are here with Mr. Smith, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes,
Need
sir.
a prosecutor, whoever.
I'm coming up, Jed. I'm just getting.
In
everything-
summary, this indictment alleges that on or about April 28th, 2024, in Jefferson County, Texas, you committed the first degree felony of aggravated robbery. Do you understand, sir, what you were charged with here?
Yes, sir.
If convicted, you face a term of life in prison, a term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. In your case, you would be pleading guilty. Whatever sentence shall not exceed a cap of 8 years in prison. So we are looking at no less than 5 or more than 8 years confinement in prison, or you can be placed on deferred or unadjudicated probation. I think those are the two options. Because a firearm was used, so regular probation is not an option.
That's correct, Judge.
But deferred or unadjudicated probation is, and then straight flat time not to exceed 8 years, 5 to 8 years as the two options. I'm going to order a pre-sentence report. We'll come back and then the court, everybody will place into evidence what they feel like I need to hear, and then the court will make its decision. If I follow this agreement, sir, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Is everything true and correct?
Yes.
State's Exhibit 1 tendered into evidence without objection admitted. The state you were mentally competent to enter your guilty plea, and it's being freely and voluntarily made. You know what you've been charged with. The indictment's been read for your use of it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation by your attorney. All of this is true at state, so help you God. States Exhibit 1, part of the record for all purposes. I'm going to order a pre-sentence report. We will return back on
July 7th.
July 7th, 2025. Everybody can add additional information and the court will make its decision. Thank you.
What was that?
And then Crystal, you're working on Crystal?
Yes, Your Honor, we had trouble with the tap.
And yeah, that's systemic, I'm afraid now. Yes, Don.
Yep.
Come on after.
Nice. Thank you very much.
No, I won't. It was an add-on and it didn't show on there.
It's not even shown.
No, it was not. We did it.
What are we doing?
He tested positive yesterday and you wanted him brought back today. Basically, he's asking for some more time once he gets out of jail to attorney. So 4 or 5 week reset.
I need his
Fine bearing. But I know you're going to get a test daily until he tests positive.
They test negative.
Negative.
The object is not to use drugs and stay in jail. It's to stop using drugs. You tested positive yesterday for THC. Did you want to say something?
Yes, sir.
Go ahead.
I had just got arrested a month ago, so even if I had stopped smoking weed then, I would have not been clean yesterday when I came here. I smoke copious amounts of marijuana, so if I smoke 2 ounces, it's not going to come out of my system in 30 days, you know? So I came here only because it wasn't that I'm not trying to get clean. I am trying to get clean. I'm trying to do the right thing. So it's not me being in jail is going to help me do the right thing, but I can guarantee that next time I do come to court, I will be clean. I will not be dirty. I will be clean. I will be on top of my game. Everything you need me to have getting done, I get it done.
How old are you?
I'm 29, sir.
You think it's about time you grew up and matured and became an adult, or are you going to stay childish the rest of your life? Really? How long have you been using drugs?
I've probably been smoking weed. I don't use drugs, I only smoke weed, sir. But since I was like 14 years old.
14?
Yes,
and you're
sir.
how old right now? 90? You were born in 95, so you're 30 years old?
29.
You're going on 30 in
Yes, sir.
October?
Yes, sir.
No. Okay, well, how many, each time you use drugs illegally, it's a crime, it's a foolish decision, and it's a wrong decision. How many of those wrong decisions do you think you've made?
I've made a lot, sir.
Thousands?
You did a lot, sir. I can agree to that.
Yeah. Okay. Well, it's never too late to mature.
Yes, sir.
But talking about it doesn't do it.
That's what I'm trying.
You got to
I'm trying to show
walk the walk. You know what I mean?
Yes, sir.
Everybody says, just let me out of the mouse trap. I'll never eat cheese again. But there are a lot of cheese eaters.
Yes, sir.
Like a mouse. Just let me out. I'll never eat cheese again. But that's the nature of their beast, of the beast. They eat cheese.
Right.
Similarly, people get attached to drug usage. And they will say and do anything to get out of confinement.
No, that's not the point here, sir. I have school that I'm.
You can say no all day long. Don't make me sound foolish. You and I know.
Trying to go.
Hold on. How long have you been using drugs?
Since I was 14.
Half of your life.
Correct.
You don't think that's a consistent wrong choice lifestyle?
Yes, sir.
Okay. Well, anyway. What was your bond? We revoked it. Yes.
It was, I believe, 15,000.
Yes, sir.
Well, he's not going anywhere testing positive. We're gonna have to see what's in his
If you would
system.
reinstate his original bond as soon as he tests.
I don't think so.
Okay.
No. I mean, it's gonna be doubled and they'll have to have a drug like all of them, but you're gonna sit over there and we'll test you and see if you're testing positive or not, but until you test negative, I'm not letting you amble out of here. You understand? Sit over there.
You understand.
Thanks.
I just have school I'm trying to attend.
You can talk about it all day long. You got to do it, sir. What else?
It's all, I was gonna reset him. He'll still test positive today. So just,
Okay.
Reset him for a announcement, maybe his family can hire an attorney.
Okay. That's Mr. Murchison.
We done.
He's gonna get tested, whatever. John, John West, where's John?
Never just gonna be late today.
Hey, David,
Yes, sir.
we got some stuff. I hope you can move some things here. I've got Arthur Gilder.
Judge, that case, but he has a second felony
Yeah.
that I was aware of, but I had not spoken to the law enforcement officer, and I need to do that, so I got to try to.
But
2 weeks, good? All right. Where's Mr. Gilder? Right here?
we don't.
2 weeks reset, please. We need to, yeah, we need to move those, we need to move that one way or the other in for his life, so we can see what direction you go in. Just reset 2 weeks. Aretha Jackson. That's a.
Judge, that's a case where she would like to ask her case to be set for trial with another attorney, I believe, someone that might help her with the case more so than I've been able to.
Well, that's, I mean, you're a competent lawyer. I mean, you're gonna try cases. Are you able to hire somebody?
No, I'm sorry.
All right. Well, Mr. Grove is a competent attorney. Yeah, he was a great trial lawyer before I was a lawyer. So.
I believe she thinks her case may be able to be moved quicker if she had someone who did.
We're gonna set it for trial, David, and you're gonna be the lawyer on it.
Yes, sir.
Y'all can move it.
Trial.
Otherwise, let me know. Was there an offer?
Yes, sir.
What was it?
The offer was deferred adjudication.
Okay, yeah, she understands that is not a conviction and that it can be shortened to 1/3, whatever the amount of time is on the deferred, and that keeps her record clean. You understand all those things? All right, we'll set it for trial. Okay, that's your choice. If you're convicted though, if you're convicted at trial, that's a forever conviction. It's not like deferred where you're clear.
Yeah.
You just need to know there's a big difference between a jury cannot give a deferred probation, only I can. And that's no longer available for you. Keeler Maldonado. What are you going to do on Mr. Maldonado? Here. Come on up. You're doing. What are we going to do on this one, David?
On Mr. Maldonado requests his case be set for trial.
Well, what was the offer on this one too? Was this a deferred?
No, sir, I
No.
believe that was his Maldonado. This was a PDC time, let's just say, to find the file.
I need, I think I got it. Hold on. No, I don't.
Oh, here, I got it.
No, he's getting more.
Are you working somewhere?
I'm working with my cousin by school, landscaping. I'll be going with him 2 to 3.
Well, how much do you make?
100 per yard. Whenever I go. I got a new car. It's gonna be one.
What's his bond on this case?
$30,000.
Who posted your bond? You did? Well, yeah, somebody posted a $30,000 bond to get you out of jail. Who did that?
Sure.
You don't even know? It wasn't you though, right? Why not? You're not an adult taking care of your problems? Somebody else is? You're in a mess. You're looking at life imprisonment. Do you know that? Do you understand and appreciate that? Do you? You're looking at life imprisonment. You can't get deferred or unadjudicated probation in front of a jury. In fact, whatever sentence you get for an aggravated robbery, it has to, 50% of it has to be served in prison. So if you get 50 years, you got to serve 25 years at least before you're paroled. You understand how serious this is? Do you? But you don't even know who bailed you out of jail?
Who bailed me out?
Your cousin. Who was your cousin?
Anthony. I think that's what they call him. I think it was Anthony.
Okay, what's his last name? You don't even know the name of the person who is a relative of yours who bailed you out? What kind of family is this? Y'all don't even know each other's name?
Sure, I just don't know his last name.
Have a seat over there. Okay. We'll get back to him in a little bit. Okay, David, on Phoenicia Mims.
That'll be a plea judge. I don't ever signed up yet.
Okay. Miss Mims, he's got to do some paperwork. If you can get that done as soon as possible. Thank you. Anthony Owens. Just stand by. She's going to do some paperwork and work with you here. Thank you, ma'am. Anthony Owens, what are we going to do on Anthony Owens?
Anthony Owens wants this case to trial.
Where's Anthony Owens? That's you? You have a seat over there too. Right over there. Jacali Palmer.
Judge, if I could speak to the prosecutor, District Court, about that. He'd like to withhold that for a little while.
And Dalen Parkerson.
Dalen Parkerson, Judge, I'd like to have a reset on that. There's some additional investigation.
How much time do you need? 4 weeks?
4 weeks.
That's all? Okay. That's reset. Darius Smith. Darius, get him a sentence. Darius Smith.
Darius Smith would also like his case set for trial, I believe.
Who goes to trial for unlawful possession of a firearm by a fellow?
I'm not trying to put it in, sir. I just know Mr. Rose is a busy man, and I was just trying to get the case resolved.
Oh, you were.
Well,
He says he.
I'm not offering information.
schools and all parts.
What's the offer on it? What's the offer on it?
The offer on it is 4 years. 4 years TDC.
Hold on, but I'm sorry, y'all are going a little fast. So is Mr. Palmer going over there?
Yeah.
Okay. And then Mr. Parkinson being reset.
Right.
Okay, thank you. Sorry.
Yes, I just.
It's not on the highlighted. That's fine.
Zane, you're still testing positive. You're not getting out until that changes. So you're taking it into custody.
Say is he's lying with me, fucking will be back.
Again, Darius Smith. Yeah, this conviction on June 7th out of Ellis County. So every time, so you commit a 3rd-degree felony each time you're unlawfully possessing a firearm.
That probably, hold on, let me clear the locks.
Yes, please.
Yeah.
What other
and-
convictions do you have?
I have a felony in marijuana,
The one in 17 from Ellis County, right?
Yes, sir.
What else? That's it.
Mr. Newman, please raise your right hand and swear to harbor and the truth and the truth and the truth shall be God. Need you to each of your right hand. Okay, please sit down.
There's a firearm underneath your seat, the driver's seat.
Yes, sir.
And what's your defense on this?
I had forgot it was there that morning.
That's so what?
I understand, but I had took it.
It's an extended mag style where it's got 30 rounds, Judge.
See, you're not eligible for probation. You're not eligible even in front of a jury for a conviction. Prior felony conviction. I don't know if you understand that or not, so.
2.5 right now in school.
So what? Yeah, you got like, just like me. What would I lose if I commit a crime? A lot more than you. That's why I don't commit crimes, but.
So I had got there from my home.
It doesn't matter. It's illegal possession. I mean, it's the lowest is 2. They can do 2. Yes. How much time does he have credit?
Judge, he thinks he has only a week. Probably not much.
2 days.
Hmm?
2 days.
Yeah.
Yeah. 24 CR 1771 is called the State of Texas versus agreement's been reached of guilt and place you on deferred or unadjudicated probation. CR 2223, the state of.
It's gonna be a probation amendment. We don't have paperwork, we didn't turn anything in.
You see what kind of problems you can get yourself into if you don't act responsibly and you let your passion get the best of you, which happens to all of us from time to time. So please see the probation officer and you will begin probation. Thank you. Anything else that is sound?
No, Judge, I do have Rodney Broussard.
Yeah.
And it's gonna be a probation amendment. We don't have paperwork, we didn't turn anything in.
Okay.
But he agrees, and I don't know if you want to bring him out or I'm just wanting to meet with.
Who is it?
Rodney Broussard. He's gonna agree to a safety and a 60-day jail sanction.
Okay, this is an MTRP. Yeah, bring him out, please. Rodney Broussard, thank you. Probation officers. That's it. All right, we call two matters, 23 CR 1813 and 23 CR 2223, the state of Texas versus Rodney Allen Broussard. That's you?
There should be a third, Your Honor.
A third one.
MTRP. It should be 2512 and 40.
24 CR 220. There are three first amended motions to revoke unadjudicated probation. The defendant is on probation for evading arrest or detention with a motor vehicle in each of these cases, right? Third degree fire. The first, well, these are failures to report. But look one. There was a motion to revoke probation filed on February 20th, which alleged those first three grounds of failing to report August, September, and October 2024, failing to provide verification of community service hours, failing to pay court assessed fees. And then later on, the first amended gets filed on March 27th of 25. Like 5 weeks later, and it alleges failing to report to the probation office. All right. In August, which is already in the first one, December of 2024, which is a new month, January and February. So we have allegations that he failed August, September, October. Nothing in November.
He was in jail.
He was in jail. Then was he released from jail? And then December, January, February. Half a year. How much time does he have credit on all this? Please. Okay, while we're looking that up, what's the deal?
The agreement is for him to go to safety. And
what's the deal? Why is he not reporting? Because the one thing you have to do is report. I don't care. I mean, I do care. You can fail to do everything else with good reasons, but if you fail to report unless you're physically unable, then you're not on supervision. And I open the door for one, I open the door for everybody. If there aren't consequences that are severe, you got to report. You got to show up. If you don't show up, you're marked absent and you're gone. And probation is a waste of everybody's time if you're not going to appear. We can't be searching for them. How many? 5,000 people? Roughly 5,000 people. Whatever's good for you, they can go. I want the Rodney Broussard rule. I'm going to not report for a while, and then when y'all catch me, then I'll be able to get out of jail free. You don't have 166 days. 5 months. So what was the deal? I mean, he had the first one, then he's in custody, then he gets out and he just doesn't do it again?
Exactly.
Well, how many chances do you get?
August, I actually got picked up that day that I was thinking to my probation.
Yeah.
Warrant.
Whatever.
No,
I mean,
really.
everybody says that. The point is you weren't there.
Yes, that.
But he had a warrant out in Louisiana and he was arrested. He was in jail.
Yeah, it was literally some unfortunate circumstances. Even when I got out. Sorry.
Okay. Well, if you're in custody, you can't report. I mean, it would be a defense. But when were you not in custody? When were you free and didn't report? That's what I want
got
to know.
out very end of December.
So August, September, and October of 24, you're in custody?
Yes, sir.
Is that right? Why would we file that if he's in custody? He can't report if he's in custody.
I believe he was in custody August and September.
No, I wasn't. I got picked up August 14th.
Which she'll know.
If he was in custody somewhere else, Judge, I'm not gonna have that information.
Where were you in custody in August?
Louisiana.
He had a Louisiana warrant.
He was in custody here.
Well, they picked me up here August 14th, over Louisiana warrant.
And then you went to Louisiana in December, was there for a couple of days, they let you out.
I was there for about a week and a half. And then I got out right a few days before Christmas. And then the holidays and then January. So pretty much I was back at January and then there else. And then I missed January and February. And then they immediately picked me up on warrant for that. And when I got out, I didn't really have a place to stay or anything. It's not the right thing or anything. I have no means of transportation due to situations that I put myself in. Because of the unfortunate thing that kind of it's not really, I don't have a place to stay or really count on. I took myself in to report and go to make those calls to make sure that I was able to go to push it. Because failures on my end, but also through some very stagnant circumstances. That's where it fits. That's a good environment. That's really.
It was in September when I talked to your brother. He was bringing you up in the program. And that was September 13th. So you weren't in custody anymore.
Could be off by a month.
Yeah.
Okay, what's the answer? What months did he fail to report?
January and February 2025. For certain.
And he got out in July. He got put on probation on July 24th.
Yes, ma'am.
And he did not report in August and September.
I know, but if they're in custody,
Yeah,
they can't do that. And that's the question is, it seems, I know what he's saying, what we're saying, but it's not matching. I want to know what the truth is. And that's why I want to know what is accurate.
It's possible he was in custody in August. It's possible he had reported in August, and we don't have that exact date. But he was released in December. The amended.
How often was he supposed to report?
And well, he went to his initial intake in Beaumont, then he never reported to me. So I've never actually seen him in the office, but he should be reporting at least every month or 2 months. When he
But
got
they're
out.
ordered to like once a week, once a month.
But I never saw him to give an assessment to see where he was gonna.
Oh, he absconded from it.
Before he ever saw me in office.
Explain that.
Well, like I said a minute ago, he was picked up.
No, he hadn't been picked up for half a year. He's been available to report. How many times since you were released in July, how many times have you been to our probation office?
One time.
One time?
Yes.
One time?
For initial intake.
Yeah.
One time.
End of July.
In July.
End of July, I enrolled into the probation.
And, okay. It's May.
But then in August, I was picked up and I'd gone to jail.
So you've been on probation for 9 months and you only reported at the beginning?
The very first report after he got.
9 months you've been in custody?
The judge.
No, I want to know that. You lie to me and you're gone.
No. You're on.
Go ahead. Try to trick me. You're gone. I got 3 cases here. And you're looking at what, 10 years on each one? Go ahead. Try to fool me. And you tell me in 9 months that you hadn't been able to find your way to the probation office?
He was in custody for 5.
I want to know if he was in custody for 9 months. If he was, that's fine. But if he wasn't, shame on him, because that's what I'm being led to.
That's the dates that he was in Jefferson County.
In Jefferson County, it was September 18th to 12/24. So that's a little less than 3 months. Then he's in Jefferson County, 3/25 to 5/25, May,
That's to today.
today. So then we've got from 12/12, well, he was released in August, you said? Or July?
He was put on probation at the end of July.
Okay, so we have something in August we don't know about. He never reported in August at all. Then he gets put in our jail on September 18th. He's released on 12/12.
To go to Louisiana, but he was only staying about a week and a half in Louisiana.
Okay.
So he failed to report January, February.
All right.
In August.
August, January, February. Okay, 3 months. That fair? It's fair. But you can't do anything else. You got to report, or you're AWOL. You ever been to the military? When you go AWOL, they arrest you and you're in the brig. They don't put you on the front lines. You're in the brig. But you got 3 cases here. And what was going on in Louisiana?
It's the same case.
It's not the same case. It had to be a different case, sir. What happened in Jefferson County, Louisiana doesn't have any responsibility over, we do. What happened?
What he's saying, Judge, is that he evaded police in
The
Texas.
same thing?
Into Louisiana and evaded those police in Louisiana. Same day.
Do we have a problem learning a lesson?
Yes.
Okay, so it says. What's the status of the case in Louisiana? Mr. Galmore, what's the status of Louisiana?
I don't have a judgment or anything from Louisiana. What was the outcome?
Yeah, I went there and took the part and put me on probation. My probation it started in January.
Okay, I think I know. What are we doing then? Now, what do we want to do? I'm not talking about you. I'm talking about the state and the defense.
I want to let him go to safety and see if he can be better this time. He was only on probation really for a couple of months. He got out of jail. He didn't report. He should have definitely reported. But I'm hoping that if we send him to safety, he can continue all 3 of these probations and his Louisiana probation. And if he doesn't, we'll revoke him and we'll sentence him to prison.
That's pretty.
Okay. All right. What we're about to do is what's going to be called the Rodney Broussard rule from now on. You get to do this and you get a chance to go to safety. Is that what we want to open the door? What's good for him is good for everybody. Is that the message we want to send? You can scamper out for a few months and we're here to help you. Do it. No, we've got to force you to do the right thing. I'm reluctant to open that door for everybody because that's what I'm going to do. But I'll do it. Everybody gets this then. All right, on these first amended motions, the state, you failed to report in allegation 4 in each of these cases. Is that true or untrue? Are you pleading true to that voluntarily and because it is true? You understand that plea of true?
Yes.
And knowing plea of true is enough to grant a motion to revoke probation. The probation can be revoked. You can then be found guilty and sentenced up to the full range of punishment. Knowing that, do you insist on pleading true today in each of these allegations?
Yeah.
Right. In each case, 1813, 2223, and 2222. Okay. Even though there's enough evidence to revoke, I'm going to continue you on probation. And there will be terms and conditions of probation, which will include an additional term of entering and successfully completing the substance abuse felony punishment facility. The cases. Sign those. Those are all the 3 cases. You will be continued on probation, and we'll see where that goes.
Thank you, Judge.
Here. On Anthony Owens. So that you come on up, sir. Mr. Owens, we're going to. Anthony Owens, you have over there somewhere. Thank you.
Yes, sir.
All right. You, who's your attorney?
Oh, thank you.
David? Go.
You could sign people up.
You signed some people up. What were we gonna do on this case?
Oh, you said trial.
He said.
Yeah,
You said.
okay. That's what you want, right?
Yeah.
You guess.
Yeah.
You're not sure?
No, I'm not. I don't want to do no time. I just came on.
Well, that's what happens when you get convicted at trial.
Yeah.
All right. Why don't you talk to him a little bit more so that you, but you're gonna, you passed the drug test. You're okay. That's a good thing. Just have a seat and he'll be with you in a minute. Jacali Palmer, Mr. Palmer. Where's his file?
Your judge.
On the other hand, you did not pass. You knew. What's his bond, please?
It's $6,000.
All right, it is double to $12,000 and let's have a drug patch as a condition of your bond. Don't interrupt. Who is your attorney? Is it
David Grove.
David Grove? Okay. You need to talk to him about where this is going to head to, because this doesn't help you on this case.
He's supposed to be probation.
Huh?
So he was supposed to be probation, right?
Yeah, well, when you're testing positive, we can't dispose of anything until you're clear headed. That means your drugs are out of your system. You're going to get taken into custody is what we're going to do. And then we'll bring you back tomorrow to see if you can pass. If you pass, then we can get you on probation. Okay, that's what we're going to do. Sir?
Can I explain myself?
No, you gotta wait till your attorney. Just have a seat when your attorney comes in. How do you explain drugs in your system? You can't explain them away, sir. You're just kind of stuck with it. Where are we? Bruce? Yeah, Bruce, come on.
He said, where was client?
Who is it first? Who is it?
Crystal Vaughn.
Okay. Crystal Vaughn.
She's in custody.
What else do you have? I got Vaughn. Who else?
That's all it is.
That's it? Thought you had 2 or 3 of them.
Yeah, well, we took care of it.
Your Honor.
I can't get that thing to fit in there. Did you have? Your Crystal Vaughn, present with Mr. Smith, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment clause proceedings summary?
Yes, sir.
In summary, this indictment alleges that on or about January 19th, 2024 in Jefferson County, Texas, you committed the 3rd-degree felony of evading arrest, detention with a motor vehicle. Do you understand what you're charged with?
The detention of the motor vehicle,
Yeah, intentionally flee from Jonathan Cabrera, a person the defendant knew was a peace officer.
lady. Okay, yes. So.
That's a 3rd-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable for this type of offense?
Yes.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which you would not be found guilty. And that would be for 5 years and a fine $500. There would be other terms and conditions of probation. If you satisfied the terms, then at the end, the probation is dismissed. If you failed, your probation could be revoked. You could be found guilty and then sentenced up to 10 years in prison. So it's got a lot riding on doing the right thing and following the rules. If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
I show you what's marked to State's Exhibit 1 here. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and
Yes.
correct? State's Exhibit 1 tendered and
Okay.
released without objection admitted. This states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, brother. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true. It states so help you God.
Yes.
States Exhibit 1, part of the record for all purposes, and the court acknowledges those are findings of fact that the court is positively making in the record for this case. pre-sentence report ways?
Yes, it is.
I'm going to follow this agreement, if nothing further, and place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions that the probation office is going to go over, will go over with you. Make sure you follow those. You're going to be fined $500, and this will pass quickly enough as long as you follow what is required of you. At the end, your probation would be dismissed and you would not be found guilty. You also are going to be required to take a defensive driving course. That's a win-win. It helps you make better choices. Plus your insurance will reduce. I mean, it's a win, yes, everybody. It's a good idea for everybody to take it after a period of time. Okay, please see the probation officer. Thank you. Which is, thank you. Okay, that's about a bunch of stuff here. Let me figure out what do you have? Do you have anything else down there?
I have a couple of, I think this is all David's right here.
Oh, we got.
Terrence Newman, I think this is done. Yeah. Jacali Palmer, that's David Grove. Okay,
We just put him into custody.
yeah, here. Does David know about that?
No, he wasn't in here.
Here, give it to me. I'm gonna let him know.
Okay.
It's back. Zane During, we did that one already, I believe. Right?
Yes, sir.
Yes.
Here. Darius Smith.
That's David's client as well. I think he was gonna talk to him.
That's you, sir?
Yes, sir.
Yeah.
Waiting on David.
We're waiting on David to get
Yeah.
back out. Thank you. Brighton Scott.
Judge, that one was reset. I need that.
Andre Morales, John West is, where, John's still on the
We're still
land.
waiting on him to come in from Orange. I think about 30 minutes ago, the update was that he'd be here in an hour. So maybe another 30 minutes before he gets here. I'm not sure what we're gonna do.
I've got Ty Cooley, that's John West. Well. Anthony Owens,
Judge, he's waiting to talk to us, bro.
what are you gonna do on Anthony Owens?
Let me make sure, Judge.
We have Kanisha Mims, Anthony Owens.
Kanisha Mims is plea, and I just signed her up, and I'm trying to get out of that. Let me just give Mr. Owens, make sure that I'm not confusing him. Mr. Owens, I think would like to have it reset for a couple of weeks. I have him down as a trial.
Where's Mr. Owens?
He's outside.
He needs to get out. Come
Yes,
in
sir.
here. Mr. Solano? Is that you?
No. Yes, I go talk to my cousin.
No, David's is David your lawyer?
Yes, sir.
Yeah.
He's gonna be a plea. Yes, sir.
Okay. You need,
I need to sign him up, Judge.
I understand. What are you sitting in the box for? Did I put you in the box?
No, I asked him to go there and sit down.
Okay. What do you want him now? Where do you want him to go when you talk to him? And
She cleared it, you gotta leave all the. Okay, just relock. Just.
Judge, if I could take him out front, that'd probably be the best place.
okay,
All right.
well, okay, I've got Mr. Solomon and I've got Mr. Solano. What do we do?
Mr. Solano will be a plea.
Struggle here. Then I have Tanisha Mims.
That's gonna be a plea. It's Solomon, we need an update on. Solomon and Solano are two different people.
I understand, and David says those are pleas.
He didn't. Solano's a plea. He didn't announce Solomon.
David, you should hear.
Oh, what did he say? Plea? Yeah. Sorry.
And then I've got Corlina Solomon. Is that? What do we, what did she say? What did Mr. Grove say on that? What are y'all gonna do? For what? Oh, you don't know? Okay. All right. And then I've got, John's cases, John West. Can you call him up and see where he is, please? Okay, on Rodney Broussard, Dustin, we took care of that, right? And then Langston Adams of Rakisha Diaz, that was to be dismissed, which we did. Right?
They said.
That got dismissed.
I submitted it, but I don't think you signed it.
Yes. I didn't. I don't have it. I dismissed a James and jail. But the other one is on its way, I guess, huh?
Yes, sir.
Good. Diaz, where he should be Diaz.
No. There's 2 years probated for 5 and
And what did we do on Aretha Jack? Where's Aretha Jackson? What did we do on that case? State, do you remember? I don't have a note on it. I had a big arrow on it.
It was reset, Your Honor.
Yeah. To reset. What did David say on Keeler out Maldonado?
That was a reset, Your Honor.
That's that page. All right, so I'm waiting on David and John on these other ones. We're in a short recess, everybody. Thank you.
Oh.
All right, your client pled guilty to the charge of operating while visibly impaired. He shows one prior that was taken, that was dismissed ultimately because it complied with statute by the prosecutor after the specified probation period. This is his first drunk driving. He pled to operating while impaired. He was referred for a screening and assessment. If he had a chance to review the report with him and argument, additions, corrections, or deletions.
No, Your Honor, it's factually accurate.
anything you'd like to say on his behalf?
Judge, I saw the recommendations. I believe they are quite appropriate. It's my hope that he'll comply 100%, put himself in eligibility for early termination. I believe that how he's done on bond reflects how he'll do on probation. I'd ask terms and conditions be adopted. Thank you.
Sir, anything you'd like to say? Pardon?
No, sir.
You sure? I'm just asking. You don't have to say anything. You seem reluctant. If you want to say something, you can say it. If you don't, I'm not forcing you to.
No, sir, I'm good.
You just want to get out of here, huh? Well, I don't mind telling you something here, guys. I don't necessarily, I think I've made this clear. I don't really agree with some of the new laws that have been enacted, but you know what? That's the legislature, and some of us still around here, and I don't mean in this court, but some of us in certain branches of government are going to respect the separation of powers and understand that we're not here to supplant our judgment for the legislative branch. It's unfortunate some think they can supplant their judgment for that of the judicial system, which I just don't understand, and it troubles me greatly. But see, I'm not doing that. Okay, Mr. Clark?
Yes.
I'm not gonna do that because I'm not, this is my, I have way too much respect for the judicial system than to make my own rules, create my own laws, exert my power. I'm not gonna do it. So if there was ever a case where I think probation isn't warranted, and there's a presumption basically that you have to be released without probation on a drunk driving, believe it or not. If I can't state compelling reasons on the record to do so, and I can't here. You had a relatively low breathalyzer, 0.107 and 0.115. You've never had a drunk driving, you're 42, you're gainfully employed. You scored in category 1 on the alcohol and drug use portion, which tells me that you don't have a drinking problem or a drug problem, and therefore I'm not going to place you on probation. 300 fines, 300 costs, 75 victims' rights fee, $50 justice assessment, 7 1/4. Screening fee 60 for 785. You do have to pay cost of recovery of 150 for 935. And just let me double check something here. 40 in attorney fees, 970.
I'm retaining this, Mr. Judge.
Oh, you are? Okay, I'm sorry. 935. 2 days community service I'm going to give you until August. Yeah, you got to get that done a little earlier. Get it done by July 10th, and I want you to attend the Victims Impact Panel. So 16 hours community service and attend the Victims Impact Panel. And that's it. You're going to pay $935. We're done. If you violate, you could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, sir.
Mr. Clark, you're lucky.
Thank you.
You're lucky that I'll just let it go with that. Good luck. I wish you well. Thank you. Can you pay this today, by the way? Nine, it was too low, really. 935.
Your Honor, can you do?
500 now, $100 bi-weekly. I'll start that beginning June the 22nd. You're all set. If you need more time, come talk to me, okay?
All right,
I'm glad to give you an extension. You'll meet the probation. They'll explain the community service and set you up at the Victims Impact. Good luck. Stephen Bailey.
Thank you, Judge.
Thanks. Stephen Charles Bailey, 25W838-436A and B and C. Where's Stephen Bailey at? Is Mr. Bailey, you have to state your name? Mr. Bailey, you got to start your video and state your name. You gotta unmute and state your name, sir. Yeah, you gotta get a lot closer to your device. Now, don't test my patience here. We couldn't connect with you last time. You gotta deal with us. Get closer to the device. Make sure you understand how to use that, or else I'm gonna make you come here from Springfield. Come on, get close to the device, nice and loud, and tell me your name.
Stephen Bailey.
Where's Springfield, Ohio?
About 110 miles south of you.
Okay. Well, I'm going to let you do this by Zoom, but you have to be on Zoom for me, and you got to show up with your name designated on your screen instead of Motorola, or last time we had Samsung. So you got to stay with me. Do you know how to operate Zoom?
No, I don't. It's all new to me.
All right. Well, you're doing okay, but I got to make sure we can do this. You have a driving on a suspended and a commercial vehicle violation, operating without obtaining a CDL, a commercial vehicle, and improper lane usage. So do you want a lawyer? I'll be glad to give you a lawyer and set you up with a lawyer.
Not really. Well, that just get taken care of.
Well, we still can set you up with a lawyer. Let me set you up with a lawyer. It's gonna be a minute. We're gonna put you on mute. We'll set you up with a lawyer, and you talk to the lawyer, and then you'll come in front of me. Okay?
Okay.
Good luck.
All right, thank you.
Shaquila Shante Harvey. 25W838-266A and B. Okay. Oh. Your name? I can't go much longer, man. Well, I'll tell you what I'll do. I'll adjourn this. We've adjourned it a couple times, it looks like. I'll go ahead and give you another adjournment. Give me about 3 weeks, Lisa, and then if it doesn't resolve, I'm going to set it for trial, okay?
Okay, thank you.
Sure.
June 25th at 8:30.
Last adjournment, I'm writing down though, okay?
Thank you.
All right, so make sure you take care of whatever it is, and they can offer whatever they want then, and everybody will be happy, okay? Last adjournment. Good luck. Go down the hall, get your notice. Thank you. Lindsay Nicole Miller, 24W838-652A, B, and C. Mr. Bulahanis, your name? Where is he? Do you know?
Judge, I don't know what happened. For some reason, he went to the breakout room. I'll try to move him.
Okay, I'm going to go on to another one real.
Oh, there he is. There he is.
All right. Your appearance, Mr. Bulahanis, we lost you there. Your name?
Good morning, Your Honor. Greg Bulahanis, P36431, on behalf of Lindsay Miller.
Ms. Miller, your name, ma'am?
Lindsay Miller.
All right, so this says she's going to plead guilty, as I understand it, to operating while impaired. The super drunk will be dismissed. She's also going to plead responsible to no proof of insurance, and then they're going to go ahead and dismiss the open intox. Am I reading this right?
Yes, Your Honor.
And for purposes of arraignment, before we get to that, does she stand mute?
Yes, waive the reading, stay on mute. We ask the court to enter a not guilty plea.
You understand everything your lawyers just said?
Yes, sir.
Okay, you seem very soft spoken. Can you get up closer to that somehow, or turn that up, or she's got to yell or something? I don't know.
I got it. I just fixed it, Your Honor.
All right, ma'am, your name again?
Lindsay Miller.
So listen carefully. If you plead guilty to operating while impaired and you plead responsible to no proof of insurance, I'm going to go ahead and dismiss on motion of the prosecutor the operating while intoxicated and the open intox. And it says that you have insurance and it was verified by your lawyer. You understand that?
Yes, sir.
Wait a minute. I got to get you better than that. You got to talk a lot louder. This young lady in front of me is trying to take down everything we have. So yell at me, okay?
Yell at him.
Yes, sir.
All right. Did she have insurance in effect on the date of the offense, or did she just acquire it after?
She acquired it afterwards, but she did have insurance, but was storage insurance only. And what happened is there was some confusion in converting it to the full insurance. Here's a certificate of insurance, full insurance, May 5th, and it occurred on May 3rd. But they had insurance on the day too, but it wasn't.
Well, they had storage. I have storage. That doesn't do you any good. You can't drive.
I know.
it.
I explained everything to them, Your Honor.
And if you plead guilty to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points, license suspension or revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights, and we are not going to have a trial of any kind. Do you understand that?
Sir.
You got to go louder.
Yes, sir.
And you're waiving the presumption of innocence and waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
All right. To the charge operating while impaired, how do you plead?
Guilty.
To the charge, no proof of insurance, responsible or not responsible?
Responsible.
Were you operating a motor vehicle on May 3 of 25 at 12 o'clock in the morning on Ford Lane near West Road in the city of Woodhaven, County of Wayne?
Yes, sir.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
Yes, sir. I had about 6 or 7 mixed drinks.
What kind of mixed drinks?
It was vodka and lemonade, sir.
All right. Was your ability to operate the motor vehicle impaired due to the consumption of the alcohol? And if so, in what way?
Yes, sir. I was swerving and couldn't maintain my lane.
Do you think that you were swerving and couldn't maintain your lane, at least in part because of the alcohol consumption?
Yes, sir.
And you took a breathalyzer or a blood test?
Breathalyzer, Your Honor.
And were the results 0.223 and you so stipulate that was an accurate reading for purposes of the plea?
Yeah, 0.215 and 0.223, Your Honor.
Are you on probation or parole right now, ma'am?
No, sir.
Anybody force you to plead guilty?
No, sir.
I'm going to accept your plea to operating while impaired. I find it to be an accurate plea. I'm going to go ahead and dismiss the super drunk. And to the charge, no proof of insurance, responsible or not responsible?
Responsible.
All right, I'm going to accept that plea as well. So I'm accepting the plea to impaired, accepting the plea to no proof of insurance, dismissing the super drunk, dismissing file 52B, the open intox. I'm going to refer you for a screening and assessment. You're going to be screened today. You'll be sentenced at a later time. She has nothing on her record, right?
Right. Yes, Your Honor.
How old is she? She's 31?
32?
31.
31.
Give me a bond sheet, will you? All right, that's really high. That kind of concerns me here, okay? So here's what I'm going to do. I'll give you a personal bond of $1,000. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. And I want you to go into NA at least 2. Yeah, I'll make it twice. I'll make it twice.
She has been attending AA, Your Honor,
Good.
since the incident. She's been doing it virtually, but I indicated to her that you prefer in person, and she will do in person from here on out.
Good enough. So that'll be in person, no alcohol, no marijuana, no illegal drugs. You cannot leave the state without consent. You can't violate a law. You must appear in court as directed. $1,000 personal bond. I'm going to defer the sentencing on the no insurance. So I'll sentence her the same time on that one. We'll set a sentencing date on both of these at the same time. So Lisa, why don't you give me a date? And
June 11th at 8:30.
Hold on one second, on June 11th.
So that June 11th, I'm here, right, all day? Yeah. I mean, that's a Wednesday.
Hold on one second, I have,
If you need another day, it's not a problem.
yeah, I'm just trying to, hold, it's just my, for some reason, my, damn calendar isn't. Look, I can probably do it. Can we do it at a little bit later time? Your Honor?
You know what? I just want to start on these sentencings in the morning. How about the 18th, please? So we good that day, or is that, I'm not going to need, there was no,
Your Honor, the 11th, 18th is way worse for me. I can do the 11th.
Let's do a Monday. Let's do a Monday, Lisa. You got a Monday for me? He's retained.
Can we do a Tuesday? That's your probation day. So the 10th or the 24th?
Yeah, that's fine. We'll do the 10th. How's the 10th?
The 10th is, I can do it at, how about 9:30?
Are you gonna be here at 9:30?
I'm gonna probably be here at 9:15, Your Honor, but.
Good
I just
enough.
want-
June 10th, 9:30. No problem. And then I'll sentence her on both. So ma'am, you have to come up here today to get screened and assessed, okay? So you're gonna come up here today and fill out a questionnaire and be interviewed. And we'll see you back here for sentencing. Any questions at all? And you have an AA verification sheet to give her, right?
Yeah, I do have an AA verification sheet that I can give her for in-person attendance, Your Honor.
Good enough. Thank you very much. Good luck, man. We'll see you back here. Is he here on the signing?
Thank you, Your Honor.
Thank you very much. You have a good day.
You too.
Paul, is there anything you want to tell the court before I impose sentence?
I'm sorry. Other than that, no, sir. Thank you.
Thank you. On count one, the use of controlled substance, $125 statutory fee, 168 days in jail, credit 168 served. On count two, the operate with the presence of a controlled substance, $50 statutory fee, 93 days in jail, credit 93 served. All right, you're all set. Good luck to you, Mr. Hall.
And what was it, 125 I owe?
Yes, you owe the state. You owe the state fees.
What are those? Could you tell me, please, so I can write them down?
Pardon? The
Could you tell me
total
state
amount
fees?
is 275, or I'm sorry, 175.
Okay.
Talk to your attorney about those fees.
Okay, thank you.
All right, thank you. Court calls the case People versus John Coffey. They didn't have him up. Whose name was up there? Who's
Assistant Public Defender Natalie Pate with and on behalf of Mr. Coffey, who stands to my right. Please state your name for the record, sir.
John Joseph Coffey, Jr.
All right.
Thank you, Your Honor. Today is the date and time set for sentencing. I have had the opportunity to review the PSIR with Mr. Coffey. We have no changes or corrections, and we would respectfully request that the court adopt probation's recommendation. I will just note that Mr. Coffey does have a hold out of Fenton that he may be picked up after his release from incarceration in this county. So I would just ask if the court would consider making the restitution due 6 months after his release from incarceration, wherever that may be.
Is there anything you want to say before I impose sentence?
No, just that I'm thankful for everything the court's done for me since I've been here with the MAT program, and it's been a lot of help, so I appreciate it.
All right. Sent to the court, $125 statutory fee, $1,212.98 restitution to Meyer payable through the court that will be due 90 days after release. All other 93 days in jail, credit 93 served. Good luck to you.
Thank you, Your Honor.
Court calls the case of the People versus Frederick. Is it Karakus? Karakus.
Good afternoon, Your Honor. Attorney Jonathan Paul, on behalf of my client, good to see Your Honor and staff this afternoon. Frederick, please state your name for the court. State your name. What's your name?
Frederick Griegos. All right. Go ahead.
Thank you, Your Honor. Probation was kindly enough to send me the evaluation and the recommendation prior to court today, allowed myself and my client to duly review that. We have no additions or deletions, Your Honor. Ultimately going to ask the court to adopt the recommendation. I have sent to probation proof of my client signing up for the victim impact panel. He is already in counseling. He provided a letter, which we provided to probation. Will continue to do that. He understands he also needs to attend AA, pay some fines and costs. We'd be asking for opportunity to have a payment plan on this case, Your Honor. I do see the recommendation for sober link for 30 days. It looks like my client has been compliant since he first got the device, kind of adjusting to that, but he has been perfect since then. I think he missed a couple tests early on, but we do appreciate the flexibility, allowing my client to get used to the machine, hit his targets and have no issues. So we ask the court to adopt the recommendation, Your Honor, give my chance the client to go on probation and continue his progress.
All right. Sir, is there anything you want to say before I impose sentence?
No, Your Honor.
All right. The court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening assessment identifies the benefit of counseling and AA meeting attendance. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. So therefore, the sentence of the court, I will place you on probation for a period of 12 months. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. Do you have anything you can pay today?
Anything to pay today? No.
So be set up as a payment plan as arranged by probation. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to attend individual counseling with status reports to probation. You are to attend one AA meeting per week with monthly verification to probation. You're to provide proof of victims impact panel attendance to probation. The sober link will continue for an additional 30 days in lieu of 4 days in jail. I'll order 90 days in jail. Credit 1, balance suspended.
Thank you, Your Honor.
Thank you. Let me pass. He walked out. The court calls case People versus DRA Theum.
Good afternoon, Your Honor. Paul Tefelsky on behalf of Ms. Thiam.
Right, go ahead, sir.
Your Honor, date and time set for sentencing. We did review the pre-sentence report. We have no additions, corrections, or deletions to make to it. I would ask the court to adopt the recommendation. As it notes in there, my client has 3 children. She's married. Her husband is a therapist. He's in the court with her. This case, Judge, happened in 2020 during COVID, and she was unaware of it until just recently, and then came in here and dealt with it. She has not had any other trouble since then, and she seems to be doing well. So I'd ask the court to adopt the recommendation.
Ma'am, anything you want to say before I impose that?
I'll just say I'm sorry about everything that happened.
Sentence of the court, $400 fines and costs. There was a bond. How much was the bond? 5?
Your Honor, the bond is 500. It's a 10%, so $50 will come off of that. I believe she also owes a $50 fee.
All right. $400 fines and costs will apply the bond. I'll order 90 days in jail. That is suspended. All right. Thank you.
Thank you, Your Honor.
Court calls the case People versus Brandon Bowe.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Bowe, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Yes, Brandon Bowe.
Thank you, Your Honor. Today is the date and time set for sentencing. I have had the opportunity to review the PSIR with Mr. Bowe, and we have no changes or corrections. And we would respectfully request that the court adopt probation's recommendation. Mr. Bowe is asking for 2 months to pay the $480 of fines and costs. He does have full-time work that he just started a month ago, so he's asking for 2 months to be able to pay that.
Mr. Bowe, anything you want to say before I impose sentence?
No, sir.
Sentence of the court, $480 fines and costs. I'm going to make that due and payable by June 30th, 2025. I'll order 93 days in jail. Credit 1, the balance is suspended. Thank you.
Thank you, Mr. Bowe. You're all set.
Court calls the case of People versus Nicole Nelson. Both of them.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Nelson. She's on Zoom. Mr. Nelson, please state your name for the record.
Nicole Nelson.
Yeah, today's the date and time set for sentencing. We did review the pre-sentence reports and don't have any material changes, additions, or deletions. I will say on behalf of Mr. Nelson, I've been working with him for quite some time. He has completely, I think, changed the majority of his habits since I started working with him. He has completed treatment and did transitional housing. As the court is aware and is reflected in the PSI, he has had some other issues up north. However, while speaking with him, he is dedicated to resolving those and getting everything back on track. He is living on his own now, and has acknowledged his struggles and wants to stay up there as he's leading a different life with different people. So I hope that the court adopts the recommendation as Mr. Nelson starts this new chapter of his life.
All right. Mr. Nelson, anything you want to say before I impose sentence?
Yeah, I just want to say I'm grateful that I was actually able. At that time, it wasn't the best experience, but now that I look back, I'm grateful that some things did happen in my past to get me to where I am now. And I'm just looking forward to growing and building my relationship with God and the community and being of service. So yeah, hopefully that this will keep me somewhat accountable.
And it's good to be alive, isn't it?
Amen. Yeah.
On the case ending in 1352, sentence of the court, 24-month probation term, $555 fines and court costs, $720 probation fees. How are you intending on getting that paid?
That might be a little difficult right now, but
are you working right now or no?
Yeah.
All right. Here's what I'm going to do. I'm going to have you talk to probation. I'll have you on a payment plan that's set up by probation. Okay.
All right. Sounds good.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to provide proof of Bear River inpatient treatment program or program completion to probation. Continue and complete outpatient treatment through Bear River with status reports to probation. You're to attend one AANA meeting per week with monthly verification to probation. Maintain employment with proof to probation. Report to probation on June 3rd, 2025 at 2 p.m. That will be a Zoom appointment, and then you'll report as directed. I'll order 365 days of jail, credit 57, the balance is suspended on that case. On your other case, 24 months probation, $555 fines and costs, that will be payment set up by probation. I'll waive the probation oversight fees on that case. There's to be no use of alcohol, recreational marijuana, any illegal substance. You'll be subject to random testing as requested by probation. You are also on this case to provide proof of Bear River inpatient treatment program completion to probation. You're to continue and complete outpatient treatment through Bear River with status reports to probation. There's to be no assaulted, threatening, or intimidating behavior. No possession of any weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to maintain employment with proof to probation. You're to report to probation on June 3rd, 2025 at 2 p.m. That's the Zoom appointment. And then you're to report as directed. I'll order 365 days in jail, credit 57, balance is suspended. Thank you, sir. Good luck to you, young man.
Thank you.
Court calls the case, People versus Cameron Reeves.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Reeves, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Hello?
Hello, what's your name?
Mr. Reeves, can you state your name?
Yeah, can you hear me? I'm sorry.
I can hear you now.
Okay, my name is Cameron Reeves.
I need a camera.
Okay, hold on one second. Trying to get this shit up.
Mr. Reeves, you have to unmute and turn on your camera. Well, I don't know what he's doing now because he's staying muted. I'll pass the matter. Court calls case People versus Jacob Spellings.
Good morning, or good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Spellings. Please state your name for the record.
Jacob Spellings.
Today is the date and time set for sentencing. We did review the recommendation from probation. On behalf of Mr. Spellings, I also worked with Mr. Spellings for a couple of years now. He too has gotten sober. This is I believe the longest time that he has been sober. He did complete treatment. He hit a couple bumps in the road during his time on probation on his other case, but was always very honest with me, community corrections, and we were able to work through everything to lead him to where he is now. I think he caught both of the cases that he's currently on probation for, and this case happened in a close time period. And like I said, he's made those changes since then. He has been very, very attentive, very respectful. I've really enjoyed working with him. I think the recommendation is appropriate, and ask that you adopt it.
Sir, is there anything you want to say before I impose sentence?
Yeah, just that I think the courts, I'm in a lot better place now than I was, a year ago. And I really think that this time being sober is going to stick. I get my kids back every weekend now. I'm going to get them for weeks at a time in the summer coming up, and I'm just looking forward to how living a sober life is going to be.
The court will note that I'm imposing a fines and cost sentence because he is already on probation to me in another matter. So in this case, it'd be $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs. When do you think you can get that paid?
It can be paid either later today or tomorrow.
All right. Why don't we say pay it by this Friday then, the 30th, okay?
Okay, sounds good.
Fantastic. Pay that by May 30th, 2025. You're to complete an IOP program, included all recommended aftercare that already has been completed. I will order 93 days in jail, credit for the 3 that you served. The balance is suspended. All right.
Thank you, sir.
Spellings, good luck to you.
Thank you.
All right, take care. Court calls the case of the people versus Jack Lyons.
Assistant Public Defender Natalie Pate for Mr. Lyons, who should be present via Zoom. I do believe he made his final payment, however.
And Teresa Claire on behalf of probation, Your Honor, Mr. Lyons did stop by my office. He did provide me proof that he did pay the balance in full. He did have a conflicting court date. He wasn't sure that he was going to be able to get back here in time. So I told him that I would waive him from coming since he completed all terms of a prosecutor deferred sentence. Given that all terms are completed, probation is asking that the court dismiss the case pursuant to the prosecutor deferred and discharge him from probation with improvement.
No objection to that, Your Honor.
Defendant having completed all of the terms, this case is dismissed pursuant to the prosecutor's deferred. And yes, and the defendant is discharged from probation with improvement. Thank you. For a recalls case of the people versus Cameron Reeves.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Reeves. Mr. Reeves, can you please unmute and state your name for the court?
Cameron Reeves. Sorry, my camera, I turned it on and hung up. Apologies.
Okay, we've got you. All right.
Thank you, Your Honor. Today is a date and time set for sentencing. I have reviewed the recommendation, which is to re-refer Mr. Reeves for a PSI. He does state that he can make that in-person appointment next Tuesday at 1 p.m. and he does have the
Why didn't
address.
he get to his other one?
2 years ago, we do not recall, Your Honor. It was initially set in 2023. Since then, he has served some time in Wayne County. His recent failure to appear for sentencing last month was due to his incarceration there. Given that we are asking that the court adopt probation's recommendation so that he can make his appointment and will have his pre-sentence investigation completed so that he can come back for sentencing on June 11th.
Defendant is re-referred to probation for pre-sentence investigation and report. He's to pay a $75 referral fee. He's to pay that by this Friday, the 30th.
Okay.
I'll set a new pre-sentence interview appointment for June 3rd, 2025 at 1 p.m. That is in person. I'll adjourn his sentencing to June 11th, 2025, 9 a.m.
Excuse me, Judge.
you.
Could I say something real quick, sir?
I wouldn't say anything about the case that we discussed, Mr. Reeves.
Oh yeah, it's just about the pre-sentence investigation. It's been it was rescheduled. This case is from some years ago, but it's been rescheduled 3 times since they rescheduled it for me since I was supposed to go. So I didn't actually miss it. They just kept rescheduling and pushing it back.
Well, you missed the one because you were in jail.
Yes, you're right, correct.
Yeah, that's a miss.
Okay. Yes, sir. All right.
All right, thank you.
All right, no problem.
Thank you, Mr. Reeves. We'll be in touch.
Yes, ma'am.
I will talk to Mr. Goldstein and that's it for this block, right? And then I'll talk to counsel on Mr. Lee, and then I'll come back. Try to fix it up. Court stands in recess.
All rise.
Yes, you should.
Let me take a Shock. Michelle Rosalie Shock, 25T711721. Ms. Shock, or Detective Shapaniak, rather, your name, sir? Detective, your name? Oh, they're having technical.
Judge, yeah, he messaged me. He's having difficulty.
Mr. Makunovich, who is your lawyer?
I can't remember his name.
Mr. Crawford, come on up here. Let's call in
Mr. Bailey, join the breakout room.
Jessica O'Donnell. Derek Allen Makunovich, file number 214-642-916. Ma'am, Ms. Lawler, you can come up to that microphone. That is a microphone again. Sir, your name?
Derek Allen, Makunovich.
Counsel?
Michael Crawford, representative.
We have two charges here. Failure to clear all warrants. They say he cleared, but then he got another charge that he didn't appear on, and he has a warrant outstanding. And two, failure to refrain from having contact with the victim. Ma'am, your name?
Danielle Lowry.
How is he going to proceed on these?
Your Honor, my client will plead guilty to both of the explanation.
Is that right, sir? Is that what you want to do?
Yes, Your Honor.
If you plead guilty here, I want you to understand you have 7 technical violations. Your probation could be revoked. You could be incarcerated on this. Do you understand that?
Yes, Your Honor.
Did you sign the advice of rights?
Yes, Your Honor.
And you could get the maximum. Do you understand that?
Yes, Your Honor.
Did you read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
Your name is O'Donnell?
We have a revocation.
You understand everything here?
Yes.
You understand if you plead guilty, you're waiving your right to a hearing?
Yes.
Is the count one that you failed to clear all warrants? Again, you did as you were supposed to, but then allowed another one to occur. How do you plead to that?
Guilty.
Did you fail to clear all of your warrants? Well, let me put it to you this way. Did you acquire a warrant after you cleared them and then not clear that one?
Yes, I didn't have the money fully paid, but it's paid for. Sir. That's the question. Yes.
Is the count two that you failed to refrain from having contact with Danielle Lawler, being within 2 miles of her and her residence? How do you plead?
Guilty.
Did you come within 2 miles of her residence?
Yes, Your Honor.
Did you call her?
No.
Did you talk to her?
No.
Did you appear at her doorstep?
No.
Anybody force you to plead guilty?
No.
All right, so I'm gonna accept your plea to count one, failure to clear all warrants, and 2, violation of the no contact, at least the order not to be within 2 miles of her. What happened? Can you tell me, Ms. Warren, or Ms. Lawler?
Yeah, so I was made aware that there would be a play date between my daughter and one of her school friends who lives 3 to 4 blocks away from my house. Play date has happened there before, however, it was not Derek who took her, it was Lori, which was fine.
Who's Lori?
His wife.
Okay,
And there was no incidents that day. The date went fine. He wasn't present. Ellie confirmed that he wasn't present. I found out a few days before this violation occurred that there would be another play date. I assumed it would go just the way it went before, where Lori would be the one taking her there and he would not be present. He did send me a message for that first play date, confirming that he knew he should not be there because of the no contact order. So for the second play date, I assumed it would be the same. However, when I went to pick up Ellie that night at 6 p.m., I did witness them sitting, so we drop off at the Trenton Police Department when she comes back to me. I pulled up to the police station approximately 10 minutes to 6, and they were sitting in the back of
who's they?
Ellie, Derek, and Dory. In the back of the car, the hatch up, eating ice cream from Custard Corner. And that's something he said that he's been wanting to do, is get Custard Corner. When Ellie got in the car with me, she talked to me about the play date, and I did confirm that Derek was present the entire day at the friend's house. I verified where the friend's house was again with her, just to make sure there was no mistake. He was present for the play date and then stayed in the area to go to Custard Corner until drop off.
All right. So he didn't have any direct contact with you. He took his daughter to a location that's less than 2 miles away. You said, did you say a few blocks, right?
Yes.
But he didn't call you, other than that first time, text you to say, hey, I'm going there on a play date. It's a violation of the court's order.
No, he stated that he would not be there because he knew he couldn't
Right.
be that close.
Why are you doing that if you know it's a violation of the court's order?
That was a different location, play date, that I knew. I wasn't aware until we got this play date, how close we are, and I should have left.
Your Honor, if I might interject. Again, these are two different incidents.
I know.
The one that he said he thought would be a violation, he believed that proximity would have been a violation. The issue with this last one, he was taking his child to a birthday party, my understanding, his wife was driving, they didn't think he was within this area. So he thought it was okay for him to go, so he went, had a birthday party, left. So again, he understands that technically, upon being aware of the proximity, it is a violation, let's take responsibility.
You know how to use Google Maps, right?
My wife, I should have, as soon as we got there.
So all you have to do is put in her address where she lives and put in the address where you're going and figure out how far it is.
That's what we did. Now we have a radius bubble, so I know exactly for sure.
And Your Honor, we would like to draw to the court's attention, again, hoping that my client isn't incarcerated, is gainfully employed. Your Honor, I want the court to reconsider how it fashions this particular order, because effectively, he can't really parent his child. He can't take his child to school because of that proximity of 2 miles. He can't take her to dance class or any activities. He effectively will have no parenting time. And as you can see, based on both these violations, he's not actually trying to have contact with the victim or anything. He's trying to be a parent, a father to his child. So if there's a way we fashion this moving forward, the court could forgive him and understand the circumstance, it would help him out a lot. And the other violation, Your Honor,
Something bothered me here when I sentenced him, I can tell you that. Go ahead, I'm sorry.
The other violation, Your Honor, my client cleared all the warrants as he was supposed to his last word about the court. This additional matter came up. My client submits, and I have personal understanding of this. He was led to believe that he had paid everything off on the ticket down to 36th District Court. Sometimes the court, because of its busyness and its huge administration, can get things a little confusing. There can be a miscommunication, even within his own ranks. He walked out and thought he had paid, but then he came to be aware there was a small balance he still had to pay. So that popped up new to him after he thought he had cleared everything and was in compliance. As soon as he was aware that, okay, he owed another $100, he went down there and paid it, Your Honor.
Judge, if I could, on that warrant, that 36th District Court warrant, he did clear it on September 19th originally. He was then scheduled for a hearing as a pretrial hearing, like most cases would be. He didn't show for that hearing. That's why the warrant was then reissued. Also, he owes a balance of $290, so it wasn't a small balance that was owed on that. That has since been cleared at this point. He does owe a balance. They've given him till July to pay that balance as of today.
So it's been cleared, Your Honor.
How far do you live from the victim?
I live in Suffolk.
I'm just asking miles away.
I think 10, 15 miles, I'm not sure exactly.
Who has custody primarily, you? So I want you to understand something. When I put these protections in place, I'm doing it for the benefit of the victim, okay? But the intent behind it is that he not be allowed to call you, text you, drive by your house, be some wise guy like that. It's not that he not be able to bring his daughter to a party that happens to be within 2 miles of your residence, or bring her other places. I want you to understand. And again, you've not been a model probationer. I don't know what's going on with you, Mr. Makunovich. You got 7 violations since August.
That started out very bad, but
Well, we're not gonna get along good if you come back in front of me again. I'm promising you that.
understood.
I hope you do.
Yes.
So I'm just telling you, that's my intent. These are not the biggest violations I've ever seen. The probate, so I'm not gonna do them. I'm accepting his pleas. I'm gonna not require any additional costs, even though I could certainly justify that.
Judge, could I just make one comment though, just because when the victim Danielle issued the police report, she said that this incident would happen on April 23rd of 2025. The day after that, April 24th of 2025, Derek emailed me asking for the court's, Judge McNally's order, stated he needed them because he wanted to file a police report against Danielle, the victim on this case, because he believed that she drove past his house, and he believes that she broke that no contact order because he believes she drove past his house. I stated to him that the no contact order is not for him, is for him to not be near her, and again, could he necessarily prove that she drove past his house or not? So again, I do believe that Derek is very aware of the no contact, and he's very aware he's not supposed to be in 2 miles. I know it's difficult being that they share a child, but these are the consequences of Derek's actions.
You know, those are totally different circumstances.
Well,
She misunderstood what the protective order did, but what he was even alleging was that she came too close to him. What we're talking about is he was trying to parent his child. So
again, I think the timing of it though, the day after the incident happened, I think he was very much aware that he broke the no contact order on that day.
I don't think there's any question that based on what I've heard, that he knew it was violating the no contact provision. I mean, maybe, maybe not. I'm not gonna go into this. And when I say violated the no contact, he violated the zone within which he could drive. I'm not condoning his conduct. I'm not condoning your conduct at all. You don't get to violate judge's orders. That being said, the intent of the order was not so that you couldn't drive your child or be at your child's play date, so to speak, that's located within 2 miles of the victim's residence. That was never the intent. So I'm going to go ahead, I'm not going to impose costs, probation order modified. You're not to have direct or indirect contact with the victim. Requirement that he not be within 2 miles of the victim or residence or place of employment is deleted. Now, I want you to listen to me. Don't start puffing your chest over this one. I'm giving you a break. I'm telling you, don't go near that lady. You drive, if I find out you're driving down the street, and by the way, when you start making comments about what the judge's order should be or not be, or is, I don't tell victims they can't have contact. If she called you on the phone, the fact that you could pick up the phone and talk to her, that's a violation by you, not her. Okay? Stay away from her. Except as I've got in this order. I wrote down here, no contact with Daniel Lauer except in conjunction with circuit court. Can't read my own writing here. I think I wrote circuit court procedure, I don't know. But the point is, you two, you, Mr. Vukunovich, something bothered me here. I mean, something bothered me. So I'm gonna let this go, but don't get to thinking that I'm gonna order her not to have contact with you, and don't get to thinking that don't read any more into this as it is. If there's a violation of no contact provision, you're going to jail. Okay?
Okay.
That's it. Have a nice day. Thank you very much. Good luck. Thank you, Ms. Lawler. I appreciate it. Michelle Rosalie Shock, 25T711721. Detective, your name?
Detective Corporal Sean Chapaniak, Trent Police Department.
Raise your right hand. Solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I do, Your Honor.
Go ahead.
On Friday, May 23rd, 2025, at approximately 22:25 hours, Corporal Blake Rusnick was monitoring traffic on Fort Street and Harrison Ave in the city of Trenton, County of Wayne, when he observed a gray Ford Escape bearing Michigan registration plate Edward William David 5467 in the right travel lane going approximately 35 miles an hour, failing to maintain their lane. The vehicle proceeded west on Belmont Road, then north on Medford Road, when he observed the center brake light to be inoperable. Corporal Rusnick made a traffic stop on Medford Road, just north of Belmont Road, where he made contact with the white female driver, identified by her Michigan identification card as Michelle Rosalie Shock, 7/6 of 94. Shock was advised for the reason of the stop and ran through lien/SOS and came back suspended with 3 prior convictions. Shock was removed from the vehicle and pursuant to department policy, an inventory search of the vehicle was conducted by Corporal Rusnick, where he located a teal hip hop box in Shock's backpack. Corporal Rusnick inquired about the contents in the container and Shock stated that inside was her methadone. There is a small slit in the top of the box and Corporal Rusnick could observe chorboy and folded tinfoil believed to be narcotics. Shock advised there was heroin inside the teal box. Upon opening the teal box, Corporal Rusnick located a few folded up bundles of tinfoil believed to be narcotics, which were later confirmed to be fentanyl. Also located was a silver brass knuckle folding knife in the side pouch of Shock's backpack. Shock was advised she was under arrest and asked if she had any more contraband on her person. Shock voluntarily retrieved 2 used hypodermic needles, 1 crack pipe, and a large cellophane baggie, which contained several 1x1 bags of a white rock-like substance and several tinfoil bindles of a white powdery substance. The evidence was collected and Shock was transported to the Trent Police Station by Patrolman Jonathan Lippa and Patrol Car 1109, where she was booked and housed. Corporal Rusnick field tested the white rock-like substance in the clear 1x1 baggies using the Dectachem mobile test kit and received a positive confirmation for crack cocaine. Corporal Rusnick also field tested the white powdery substance in the tinfoil bundles using the same mobile test tech. Positive confirmation for fentanyl. The total combined weight was approximately 14 grams. In total, 12 bags of crack cocaine and 24 bundles of fentanyl were collected.
Hang on a second. Lisa, where am I hearing that feedback from? Is there, do you know?
That's from Trenton, I believe.
Yeah, ask him to just, go ahead, detective.
Hold on 1 second.
Go ahead, Your Honor.
What's that?
Go ahead, Your Honor.
So his thing is he doesn't.
Who's talking back there?
My partner's on the phone with another person. He's trying to get her off the line right now. We had a call come upstairs.
Was the defendant's license suspended or revoked?
Yes, Your Honor.
Did the defendant have the prior conviction building with intent January 4/19?
Yes, Your Honor.
I just want to make sure. So we got in the metallic knuckles, the defendant had possession, correct?
Correct, Your Honor.
Based on your sworn testimony, when authorized in all 4 counts, I find they've been made, I find that there's probable cause to believe those crimes were committed and defendant committed those crimes and there's sufficient evidence on the record for the second offense notice. I'm going to authorize. You're all set. We'll put the warrant into lien. Thank you very much. Have a good day. Thank you.
Thank you, Your Honor.
Sarah Renee Diaz, 25W837198. We'll take that one real quick. Where's Mr. Crawford at? Jeez. You got a corner here. Which one do you have? Have a seat right there if you would, ma'am, at the table. We have Jeffrey Inch down there. Jeffrey Inch. Jeffrey David Inch, 23R5133098.
Good morning, Judge.
Mr. Inch, your name?
Jeffrey Inch.
Call in, Beth. So what are we doing here? I arraigned him. I entered a not guilty plea. He has 2 counts. How's he going to proceed?
Judge, we'll plead guilty to count 2 and not guilty to count 1. I apologize. Guilty to count 1, not guilty to count 2.
All right. So if you plead to failure to attend your biweekly substance abuse disorder group during the week of May 4th through 10th, I'll just consider that one violation. Do you understand that?
Yes, sir.
Did you sign and read and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
My information is that this would be a 4th technical violation. Your probation could be revoked. You could be incarcerated for up to 93 days. Do you understand that?
Yes, sir.
All right. You understand all your rights?
Yes, sir.
Do you have any questions on your rights?
No, sir.
To the charge, you failed to attend your biweekly substance abuse disorder group at the Guidance Center on the week of May 4th through 10th. How do you plead?
Guilty.
Did you fail to attend your biweekly substance abuse disorder group between May the 4th and the 10th?
Yes, sir, yeah.
Anybody force you to plead guilty?
No.
I'm gonna accept that plea. Did somebody call Beth?
Beth is finishing up with the defendant at the window. She'll be ready.
Why don't you have a seat? I'm gonna have to take the other file first, okay? Thank you.
Emerson, Miss Foley Carter and myself would like that sidebar review.
Okay,
Yeah, on that.
I will do that momentarily, okay? Where is Mr. Crawford again? Good, thanks. Sarah Renee Diaz, 25W837-198. Your name, ma'am?
Sarah Renee Diaz.
We're gonna wait for your lawyer. Lisa, they want me to adjourn this 30 days. It's quite old already. I'm gonna wait for Mr. Crawford. But do you have another date in about 2 weeks?
2 weeks would be June 11th,
Yeah.
9:45.
So where is Mr. Crawford? My father used to tell me patience is a virtue, Lisa. I don't know if I've ever perfected that.
And he's got a lot of cases today.
I know. I know. Oh, boy. There's Emerson. Do I need to give you have somebody give you a PBT? Well, I'm gonna have somebody give you a PBT. Okay? We're gonna give you a PBT, and then you're gonna come in here and we're gonna handle your case, if you're not intoxicated, that is. Why don't you go get Ms. Foley Carter, or call Ms. Foley Carter, tell her I'm ready on that. Mr. Crawford, come on up here on Diaz, please, and I'm at least gonna get her out of here. Ms. Diaz, your name again?
Sarah Renee Diaz.
Michael Crawford representing Ms. Diaz.
Is the child getting to school more?
The child is, Your Honor, my client has rearranged her schedule since February 1st. The child will be getting to school.
You graduated, right?
Yes.
Yeah, we gotta make sure our kids graduate. How old's this child? You don't have to tell me the name. How old's the child?
13.
So we have to make sure he or she still graduates, right? Otherwise, they're gonna be living in a tent over at McCall Park over here, okay? We don't want that. So I'm gonna adjourn it. I can't go 30 days. This is too old.
Well, just
June 11th at 9:45.
Well, can we get to the week of the 16th, because the last day of school is.
The 11th.
You sure it's 11th?
It's gonna be 90 days. If you guys wanna set a bench trial, I'll deal with it.
Well, no, the prosecution just wants to make sure the child goes to school the rest of the year, so you're the judge, so you.
Thank you. I sometimes wonder. I'll tell you what, I'll make it, what do you wanna do? With the 25th?
The week of the 16th.
Is that, am I here the 25th, Lisa?
On the 25th? Yes, that's 4 weeks.
That's all right, I know. I know, we'll make it 9:45 on that date, but no more adjournments, guys. I'm either setting it, well, hopefully that's gonna be resolved that day, otherwise I have to set it for trial, okay?
Thank you.
Thank you. I'm gonna go in the back and talk to Ms. Foley Carter, right, on Emerson?
Yes.
You and I and Ms. Foley Carter. All right, everybody stay safe. What are you here on?
I am on Alger Lucky. However, there's no one here that's handling that case, not the prosecutor, not.
Alger Lucky or Alger?
Lucky. So I'm trying to get information on the case, and there's nobody here to talk to.
Judge, she came into the Woodhaven conference room. It's not a Woodhaven case though, Your Honor. It's appears to be a Brownstown case.
It's a probation violation.
Is your client? Okay, well, we're gonna take care of it. You got all these, it's probation violations.
Right, and.
You entered in a-
I was trying to get cleared up, because some people said there was a show cause.
Well, listen, you can look at the file.
Okay,
I'll come out and take it, but he hasn't been here. Mr. Lucky has apparently not been lucky, and he hasn't been here in 3 years.
well, we hope to take care of that today, Your Honor.
So do I. Where's he been? We'll talk about it when I come back. I gotta talk to these lawyers in chambers. Where's Mr. Lucky?
He's here.
Where you been? What if I showed up 3 years from now and you were
He's been
supposed to
in
be?
Ohio, Your Honor.
I'll be right back. Everybody stay safe.
Are the contents true and correct? States Exhibit 1 tendered into evidence.
No objection, Your Honor.
Without objection, admitted. This thing, what are you, is made a part of the record for all purposes. And the court makes findings in support of States Exhibit 1, and those findings are in accordance with the recitations in States Exhibit 1 made a part of the record for all purposes. Pre-sentence report will be ordered. We'll be returning back, and you'll get a resetting. Everybody will come back and sound in, and then the court will make its decision then. And please get a resetting from this lady. What is it, about 4 weeks?
I'd be June 20th.
I'm sure Justin will have it ready by then.
Okay, I have some cases here. Ernesto Solano. Come on up. I don't have any
I'm gonna
papers.
send it right to you right now.
Okay. 24 CR 2406 is called. You're Ernesto Jesus Solano. Present, you have to speak out so this lady can. Yes. Okay. You were here with David Grove, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that, just go around here and I'm going to talk to you while you're doing this thing, fingerprint. No.
No, sir.
Probably 2 hours.
No, sir.
In summary, this indictment alleges that on or about June 30th, 2024 in Jefferson County, Texas, you committed a state jail felony of operating a motor vehicle while you were intoxicated with a child passenger. Do you understand what you're charged with?
Yes.
It's a state jail felony, which means if you face confinement in a state jail for any term of not less than 180 days or more than 2 years. Additionally, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for up to 5 years and fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
I'm going to show you what's marked as State's Exhibit 1. Did you sign this document voluntarily? Did you understand it, discuss it with your attorney? Or are the contents all true and correct?
Yes.
Yes, you have to speak out.
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection.
No objection.
Admitted. I will find that here you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Correct?
Correct.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is now waived.
Yes, sir.
I'm going to follow this agreement based upon the findings, and I find that the evidence supports from State's Exhibit 1 the indictment, and I hereby find you guilty beyond a reasonable doubt of this state jail felony of operating a motor vehicle while intoxicated with a child passenger. I'm following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That is suspended. You were placed on regular probation for 5 years. You must pay a fine of $500. You shall complete a DWI course as directed. There will be other terms and conditions of probation, which are normal and customary for this type of offense.
One more signature. I think I saw it.
Confinement on a DWI misdemeanor. You get what you're ordered, 10 days?
3 days.
It's the third, DWI with a child passenger, there's not any upfront time that they have to do.
There's no upfront on misdemeanor?
Well, under that particular statute, there's not.
Right.
For DWI?
For DWI.
What, on this case, what are we doing? What do we want? Anything recommended by the state?
Not for any upfront time, Your Honor.
Okay. Then make sure you do better. All right, see the probation officer. Thank
He
you.
learned his lesson.
Okay, then I have, let's see. Here we go. Anthony Owens.
Yes, sir.
What are we doing with Mr. Owens?
That's the plea.
Okay. We don't have anything in a queue. Leave.
Oh, I'm sorry, Your Honor. It is not a plea. I think it's just the court wants them to resubmit the case and discuss it with me.
Is that right, sir?
Yes, sir.
Well, what's the offer? Do you know?
4 years to 4 years TDC, Your Honor, and he has no prior conviction. For
Is that-
is
Who's on that?
He has a prior, he does have priors.
What do you have on it?
He has it's possession of a firearm by a felon, so obviously he has a prior.
He has an assault on a security officer for which he did 2 years. That he was originally given deferred adjudication for, and he also is currently on federal supervision.
For what?
Well, you were on federal supervision.
You say current. For what?
A weapons charge.
What is the weapons from?
I don't remember exactly. I was on Pacer.
What court? What district? Eastern District of Texas? Out of Boston.
To be unlawful transport of firearms.
What was the sentence on that?
36 months. With 18 months supervised release.
Yeah. He went to federal prison and then there was supervised release afterwards.
Yes.
Total of 5 years.
Like parole.
So what's the offer on this one?
4 years TDC.
When was that federal crime committee? When was he sentenced for that?
2020.
Okay, that's a prior conviction. That isn't alleged though,
No, it is not part of the.
but it could be. If they want, if they allege it, then it moves it up to a 2nd-degree felony, if they could add that, yeah. What do y'all, is that what you want? Looking at up to 20 years? I don't think so. So what's the offer on this?
The offer was 4 years TDC, I believe.
Yes.
All right. And in front of a jury, you're not eligible for probation, so you can't get probation in front of a jury. What are we gonna do on this?
Can I go to trial? Can we take it to trial?
Yeah, I'm gonna give them time to re-indict it and add that prior conviction. And yeah, you can go to trial. You're not eligible for trial, but you're looking at 20 years, up to 20 years. That's your business. We'll do it. That's what we'll do. That's what we'll do. And
I believe, Judge, that's what he wanted to do.
all right, then we'll set the trial.
Originally.
But it's gonna they're gonna have a chance to re-indict it and add the prior felony.
So the prior
Federal.
felony, the federal, it counts to.
Yes, all felonies, federal or state count, yeah. It doesn't matter. It says a prior conviction, which means in any state or the United States district courts. Then I was in the United States Attorney's office for 20 years, and I know how that works. It's never forgotten. It's not in the past. It's always hovering. And I'll give the state a chance to re-indict, but we'll set it for trial, and that's what we'll do. And we'll let a jury decide, I guess, if that's what y'all want, okay? And there's no deals. When it comes back, we're gonna move it fast. We're gonna set it for trial quickly so we can figure out where his life is gonna go. And that's it on that. Corlina Solomon?
Oh, yes.
Corlina Solomon?
Judge, Corlina Solomon is here. I believe that Mr. Owens wanted to talk to the court about another attorney.
You don't have a right to pick an attorney. David Grove is a fine attorney. You don't get a choice. You can hire somebody. Yeah, go ahead. Go ahead and hire somebody. I'm going to set it for trial. He's going to be with your attorney and advise you until you can get somebody else. Okay. All right. Get it resetting. We're going to put it on the fast track. I want this. We can try this one. That's it. Those are fast trials to try, and we can move that. Corlina Solomon.
Yes, sir. She's been here all morning.
Yeah. What are we doing on Miss Solomon?
Judge, I think we kind of got lost in the shuffle, so to speak.
Who's on this one? State? What are we gonna do? What state want to do?
I think we had previously offered, I think we offered 7 years on it.
I believe that's correct, 7 years speedy, so you could,
She have a prior conviction or something?
yes, sir.
So she's not eligible for probation.
Well, the indictment does not have a,
I know, but it doesn't matter. It doesn't have to be. If it's proven at trial, it just needs, she needs is notice of it. Is there prior conviction that y'all are gonna use? Or not? No? Do you have any convictions? No. Just this charge?
you do have 2 aggravated assault charge convictions, that was what the judge had. Yes, sir, she does.
Where are they? Out of Jefferson County? Can you pull those up, please?
Not showing anything.
You don't have, what are y'all showing? Showing.
Those are the 2 active cases, and then she has a civil case. That's all I'm saying.
This not showing.
I don't see any priors.
Do you have a prior? Oh, I thought you said you had 2. I thought that's what y'all were saying.
Got 2 aggravated assault listed.
Oh,
She has an assault in it.
You're talking about charges that are pending, not felony
I
conviction.
misunderstood what you said.
Okay, y'all gotta be straight with me. Come on.
Yes, sir.
The problem is, if a deadly weapon, you can't get probation for a deadly weapon, in front of a jury. So you go to court, if you're found guilty, you're gonna go to prison because of the deadly weapon. That's why you gotta think long and hard about trying to, what's the offer on this? Did you say
7 years, Your Honor, TDC. Alleged to have stabbed an individual in the arm with a knife.
Or the kitchen knife. Yeah. Judge, could we reset this case for a couple of weeks so I have some more time to talk to Ms.
2 weeks.
Tallman and also.
Reset 2 weeks. Okay.
Okay.
Reset 2 weeks. Thank you. What about, get a resetting, please, ma'am. Jacali Palmer?
That was drug test, and I believe it's taken investigation.
Okay, where there's his file. And then I think, is there anything else?
Cases of the people versus Dwayne Brady.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Brady, who's present via Zoom. Sir, can you please state your name for the court? Oops.
Hold on.
No, the 18 case is the.
All right.
Mr. Brady, can you please unmute and state your name for the court?
Yeah, it's Dwayne Brady.
Thank you, Your Honor. I did speak to Mr. Brady last week regarding the case ending in 638. That case, I believe, has a balance still of 275. Last week, Mr. Brady did state to me he believes he could pay that balance off this week. As to the other case, I believe there is a balance of $960. I would ask that the court cancel the warrant in that case and ask if Mr. Brady could give an explanation as to when he believes he could get that balance paid.
Go ahead,
I
sir.
could have that. I could have that paid off probably in at least 2 months.
So, Your Honor, I would ask for an adjournment of the show cause and the case ending in 1686. If
Well, that one's not set today.
No, it is not, it's a warrant.
so, I would ask.
So on 638, I will indicate that the defendant is to pay this balance by. You could pay it by the 30th, sir?
Yes.
Pay that by. May 30th, 2025. Then on the other matter, just make sure what we got here. Well, okay, on this matter then, what, on the 18, case ending in 1686. I'll cancel the warrant. When can you make a payment on this? Sometime.
I can make a payment next Friday.
The same day as the other one?
Is that this Friday or next Friday?
You want next Friday the 6th?
Yes,
Okay.
that's when I can
I'll
start
cancel
paying
the
on that one.
warrant. I'll cancel the warrant in this one. Give them a PR. $5,000 bond. Defendant to pay, how much will you pay by the 6th?
I can pay 200 on it on the 6th.
Pay 200 on June 6, 2025. When's my next day?
We have June 11th and June 25th.
25th.
Yes, sir.
And then I'll set for a show cause hearing June 25th, 2025, 9 a.m. or as your invite indicates. Okay. Thank you.
Thank you, Your Honor. Thank you, sir.
Thank you.
Court calls the case, People versus Ashley Fuster.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Fuster, who stands to my right, please state your name for the record, ma'am. Ashley Fuster.
All right. She currently has a balance of about 1,100.
Yes, Your Honor. And I was unable to have a conversation with Ms. Fuster prior to today. I didn't have good contact information. However, she is here and ma'am, do you know when you would maybe be able to start making payments on the balance?
So I actually plan to make a $200 payment today. I just have to get home and check the mail first, and then I plan to have the rest of it paid off in the next like 3 months. Really?
Say that first part again.
Oh, I'll be paying $200 on it today. I get paid paychecks and they come in the mail. So when I get home and can check the mail, I'll pay $200 on it today. I made some payments since I got the notice in the mail a month ago. This is from 2018, so I just entirely forgot about it.
Okay, so you're gonna pay $200 today.
Yes.
And when are you gonna make another payment?
I'll get paid 2 weeks from then, so I'll safely, I'll say 150 for the next week. My plan is at least $200 every month. That should
Every
get me-
month?
Yes. If I can afford more, I will.
So you're gonna pay $200 today.
Yes.
And defendant to pay, what, 150 by what, the 6th?
Yes.
Or the 13th?
The 6th.
By June 6, 2025. And then 200 per month. Beginning in July. Okay? All right. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Samuel Hamilton.
Assistant Public Defender Warrant hearing on behalf of Mr. Hamilton. Oh, Mr. Hamilton's here. Awesome. Hamilton, please state your name for the record.
Samuel Hamilton.
Yes, we are.
Still in the hospital.
A show cause, yes, as the court may remember, Mr. Hamilton got into a bad car accident and was paralyzed from his neck down. I have been trying to get in touch with Mr. Hamilton about proof of that accident, but we've not been able to make contact. Not sure if I have the wrong number for you or, did you get my email?
Yes, I got your email.
Okay. So.
I'm done.
Okay.
He's appeared before me every time. in the same place, in the same hospital bed. I get it. I'm gonna waive all fines and costs except the statement. Mr. Hamilton, you take care of yourself.
Thank you. I really appreciate it.
All right. Court does call the case, People versus Donald Holloway.
There is no counsel on this one, and I don't have.
Yeah, my name is
Name,
Holloway.
sir?
Mr. Holloway.
Your first name's Mister?
Donald Holloway.
All right.
How you
I
doing,
didn't know.
Mr. Simpson? Okay.
You name their kids all kinds of things. All right. You owe $1,197.68.
Yes, sir. I've been paying, I'm on Social Security, but I'm gonna still pay another payment today before I leave. And I'll keep my payments up each month. I already made an agreement and I keep it up.
So you've been paying on it?
Yeah.
How much are you paying?
I've been paying $20. My wife made the agreement.
$20 a month?
Yeah. And we just got a check yesterday, so I'm about to pay my other 20.
Pardon? Okay. Why is this set before me if he's been keeping his pay?
I see it in January.
So you haven't been paying per month, which is how it's coming before me.
Oh, okay.
You have to pay each month.
Oh, I was in the hospital, so that's probably what happened. I got surgery and all that stuff.
So I'll just put in here, he's paid $20 per month. We'll continue that and we'll start that June.
Okay.
All right.
All right, y'all have a nice day.
You do the same. Mr. Hamilton. Court calls case, People versus Robert Lee. Doesn't have counsel.
Simpson.
Good afternoon, sir. Can you state your name for the record, please?
My name is Robert Scott Lee.
Okay. You're here on a show cause. I have you owing $540.
Yes, sir. I won't even try to offer. Well, I just don't. I'm on a fixed income of $1,000 a month, and trying to pay $500 at one time is virtually impossible for me. So I was hoping that I could make some sort of arrangements, payment arrangements.
Okay, how much do you think you can pay each month?
Well, the gentleman that just left, he's paying $20 a month. If I could do that.
Hold up.
No, I'm
gonna try to get the same payment plan.
Well, $20 a month is doable for me.
Now, don't be looking behind you, because you know I'm talking about you. The moment you said that.
The moment I said.
The moment you said, well, I want the same payment plan as he had.
Oh.
They started laughing. Yes, you did. Don't shake your head. You know you did.
Okay, I'm sorry. I didn't mean to.
No, you're all right. You're okay.
But yeah, $20 a month would be awesome. That would ensure.
How much do you get each month?
Each month I get approximately $1,045.
Pay $25 a month.
Okay.
Would that work?
Yes, sir. I can live with that.
That's because that's what they said you should pay.
Okay, all
I
right.
would
Well,
let you have the 20, but the one in the black, she said, give him more money. She was mouthing it up.
I'll deal with you later.
All right.
So
No,
25.
the only reason he has 20 is that was set up with our collections department. I usually don't set anything that low. So but I'll give you $25.
Yes, sir, that, I appreciate that. Thank you, sir.
Beginning in June. All right, sir?
Okay,
All right.
thank
Take
you.
care of yourself.
Just one question. Can those payments be made online? Do you know?
They should be able to, correct?
Yes.
If there's not a warrant on it, you should be able to make it online.
Okay.
All
but
right.
I can probably ask it when on my way out.
Yes.
Okay.
You'll be
Thank
more
you,
than
sir. I
happy.
appreciate you.
You
Judge
take care of
Simpson.
yourself.
You do the same, sir. Thank you.
Court calls the case, People versus Keith Malone.
Good afternoon, this is the public defender Warrant hearing on behalf of Mr. Malone. Mr. Malone, please state the name for the record.
Keith Daryl Malone.
Thank you.
Warrant, we are here for a show cause. I did speak with Mr. Malone regarding this file. He is from living in a nursing home due to some medical issues that he has. Any income that he gets goes directly to the nursing home for his medical care. So he has no income at all. He did, he said that he filed an ability to pay for him with the help of his case managers.
He did.
Um,
I see it.
so given all of that, I think at this point he's unable to pay anything. I'd ask the court to consider waiving everything.
I've already written what I'm gonna do. You wanna keep talking?
No.
Okay. Why are you laughing, Mr. Malone?
I just laughed at you because last night I did a whole probation for you, you know that. And I was just thinking, go Tarpons, had to say a Tarpons thing. I watch you every day. I have to see my name come up. I'm watching one of your things, right? My son got the same name. I was like, wow. Then I called it was me. It happened in 2019. I'm like, wow, I ain't have no money left. Since I got another knee surgery coming up, I can walk. I'm still clean and sober. I'm a motivated speaker now for drug and alcohol. So I'm doing that, but I don't get no income from that because I'm helping other people stay clean and sober. I think, man, Judge Simpson and Judge Barr had me going through these programs. Now I'm clean and sober 3 years now, due to the court and myself, but mostly myself and my help. And you were a good help to me too. You know, I know that very serious. You know, and
Thank you.
I would just like.
Thank you for saying that, sir.
Yeah, you are.
I do appreciate it.
Yeah.
I'm gonna waive all his fines and costs except the state minimums. You're all set, sir. All right. Good luck to you. Take care of
Yeah,
yourself.
thank you, Judge Simpson. Have a good day. Go Tarpons.
All right.
Yeah.
Court calls the case, People versus Lee Parker.
Assistant Public Defender Natalie Pate on behalf of Mr. Parker, who may be present via Zoom. Sir, if you're present, can you please unmute and state your name to the court? Your Honor, I do not have an explanation for Mr. Parker's failure to appear. I did leave a voicemail the number for him. I do understand he still has a balance of 569. For the record, I would respectfully request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond is set amount $7,500. Under the 10% privilege, that warrant will issue immediately. And he also does have another warrant out of 1482, so. Court does call the case of People versus Donald Pittman.
Assistant Public Defender Natalie Pate with on behalf of Mr. Pittman, who is approaching. State your name, sir.
Donald Pittman.
Thank you, Your Honor. I have had the opportunity to speak to Mr. Pittman about this matter. He does still have a balance of 410. He thought he had already paid this. He did then provide me proof, and I did double check in JIS that he did not pay on this case. However, he did make a $276 payment on a ticket case on April 4th of this year. To that end, Mr. Pittman is asking for an adjournment of the show cause. He does receive SSDI in the amount of $1,300 monthly. He states he would be able to pay roughly $100 a month on this matter. So I'm asking if the court would consider a payment.
Would he begin paying now?
Next month, if that's okay.
What day do you get your check?
On the 3rd.
On the 3rd.
Yes, sir.
All right. You're to pay $100 per month beginning June 6th,
Thank you.
2025.
Yes, sir.
Till it's paid in full.
Yes, sir.
All right.
Thank you.
Thank you, Your Honor.
Court calls the case, People versus Shania Reed Ginyard. No counsel. Reed Ginyard. No response. What do I have, sir?
465.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. To give 10% privilege. That warrant will issue immediately. Court calls case People versus Jessica Shaw.
Good afternoon, Assistant Public Defender Warren Attorney on behalf of Ms. Shaw. I don't see Ms. Shaw here in the courtroom. I did attempt to make contact with her. I was unsuccessful. I don't have an explanation for her failure to appear. I would ask for adjournment.
Yep. Come on.
634.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $7,500 to give 10% privilege. That warrant will issue immediately. I'm like parched. No.
Can I
I'm like-
get something to drink, Your Honor?
Did you have a moment?
Just don't do anything important.
Okay, I won't. Trying to hurt me. Court just called the case. People versus Mamadi Sidibe.
Assistant Public Defender Natalie, on behalf of Ms. Sivity, who may be present via Zoom.
Thank you, Ann.
Ma'am, if you're there, can you please unmute and state your name for the court?
That's good, Alan.
So, Your Honor, I was able to leave my client a voice number, last number our office had for her. I do not have an explanation for a failure to appear and would request an adjournment for the record.
Yeah, bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000 of 10% privilege. That warrant will issue immediately. Court calls case People versus Heather Skidmore.
Public Defender Natalie Pate with behalf of Ms. Skidmore, who is present via Zoom. Ma'am, can you please unmute and state your name for the court?
Yes, good afternoon, Your Honor. Heather Skidmore.
Good afternoon.
Thank you.
I have her 325.
Yes, Your Honor, and I was able to discuss this with Ms. Skidmore. She is asking if the court would consider allowing her to do community service. In the alternate, she states she would be able to start paying $50 monthly beginning on May 30th. She is currently on probation to 14B, and it is my understanding, as well as hers, that she is completely in compliant with that probation. I believe testing is a requirement of that as well. She also states to me that she has been about 2 years sober since 2023 and is asking if the court would consider allowing her to do community service. Understanding the balance is $325. If the court would like her to pay that full balance, she's able to pay $50 monthly beginning the 30th of this month.
I'm not going to do community service. What I will do is $50 per month beginning May 30th, 2025. All right.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Thank you, Ms. Skidmore.
Yeah, thank you, Ms. Pate.
Court calls the case People versus Joseph Swope.
Assistant Public Defender Natalie Pate on behalf of Mr. Swope, who may be assumed.
Both on,
No, the one ending in 12.
got it. That's it. You know where your client is or no?
No, Your Honor. For the record, I respectfully request an adjournment. I was able to leave a voicemail, however, at the last number my office had for him, I did not hear a response. I respectfully request an adjournment. For the record, I believe the balance in this case was 395.
Bench warrant will issue for defendant failure to appear, bond set in the amount of 5,000. 10% privilege. Warrant will issue immediately. Court calls case Google versus Henry Williams.
Assistant Public Defender Natalie Peak on behalf of Mr. Williams, who may be present via Zoom. Williams, if you're present, can you please unmute and state your name for the court?
No.
Your Honor, I did send him the Zoom and leave a voicemail. I did not hear back from him regarding this. For the record, I respectfully request an adjournment. I do understand, I believe there's still a balance owing of 70 and 40 cents.
Bench warrant will issue bond set in the amount of 15,000. Give a 10% privilege. That warrant will issue immediately.
Thank you, Your Honor.
Cases of the people versus Susanna Williams. They're both on? No.
No, the 2019 cases.
Got it.
The other was a companion one, right? I
Good afternoon.
Hello, what's your name?
Susanna Williams.
All right. On the case that you're here before on right now, you owe $920 on that case.
Okay, I wasn't aware of the fines or exactly how much, but I was prepared to make a payment today, so I was just under the impression that when I did the 93 days for that, I didn't have any fine. No. I already did 3 months in jail for the donut case for the $5. So I didn't think I had to pay $1,000, but I have like $50 I can pay today and make $50 payments.
And you can make $50 payments each month.
Yeah. I live check to check or month to month, and I'm fighting for disability. I only get $500 a month, so I'm getting like half of what these
Pay
people make.
$50 today
Thank you.
and $25 per month
Perfect.
until paid in full.
Thank you.
All right, that's on that case. You also
I have, go ahead.
2 warrants. Let me just make sure. No, it's the same case. I'm sorry.
You have
1 warrant.
Mhm.
Other fines and costs. You did.
I think it was for the same thing. Oh, sorry. I just lost the middle.
That case, you owe $414.
Oh, it's the same case, but like 2 separate fines. 2 separate
The
cases.
case we just did is this one.
Okay.
This one,
Can I make $25 payments on that one
hang
then?
on.
Sorry.
I'm gonna cancel your warrant.
Okay, thank you.
Give you a PR.
Perfect, thank you.
Since I put 25 on that one, I'll say defendant to pay 25 on this one.
Thank you.
All right.
How much total today then? Because I didn't bring.
Oh, you got $50 today.
Okay,
Pay the 50 on the one case that you're here on.
yeah,
And then
okay,
it's gonna be $20 per month beginning in June on each of these other 2.
okay, that'll work. Perfect. I can do that.
All right.
That's all? I'm not going to jail today?
Want to? You should.
Hell no.
Pay them.
I'm sorry, I said it in the court. I was the first day I've ever been, I was nervous coming because I came at like 8 this morning. Like I just lost the mail, so I just
Okay,
knew it
they
was
sent
you.
you to jail already.
But no. I'll just go pay the fine. First time I come to court where I don't gotta go, I'm not turning myself in or anything. I'm
Did
good.
you sure you don't wanna go?
I'm perfect. I'll be all right. I think I'll be good.
We got room.
I told you I did the 3 months
Then I'll
for
take
some whole ass
you
donuts,
You're all
some
set.
sauce, yes, some stale donuts.
All right.
All right, bye, hon. So 50 today
Yes, ma'am.
and 25,
Yes, ma'am.
or, yeah, I'll figure it
On
out.
each day.
I think that's what it was that I went to pay the payment and I didn't know I had two cases.
Got it.
But
Okay.
have a good day, Justin. Thank
Take care.
you.
Not talking to you. So hold it. Why? Who are they back there? You don't have a case?
No, we're here for Kiayla Key.
For who?
Kiayla Key.
Is she in custody?
Yes.
I'm thinking you need to be in court today.
Oh, you might be in the wrong court. So I'm sorry. I didn't mean to blame you for everything that, okay. You got-
Yes, thank you. To 1:30.
I arraigned her that she didn't that she used alcohol or didn't. So I'm gonna go ahead. You guys asked me to adjourn these trials. There's no way I can go on now. But I don't have a bond violation. So all I can tell you is you can take her to Judge Hessen and you can explain. I would have been happy to do, but I didn't have it as a bond violation. I didn't set that as a bond. So we'll set all these, Lisa, for next week, Monday. Apparently they're up for trial, but she needs to go in front of Judge Hessen on the bond violation. I don't think it's fair for me to be the one to do that when I didn't conduct that hearing, when I didn't have that as a condition. But it's 0.1770 he wrote down here, okay? That's it. Good luck. Go down in front of Judge Hessen. I'm really worried about you. And the thing is, I can't say I haven't tried. Good luck. Let's do Alger Lucky. I know you guys are busy back there and I haven't been able to get you in here. Alger Lucky. Alger Ivory Pierre Lucky, 22B1397938.
Good morning, Your Honor. Kimberly Bell, P44711. I'm appearing on behalf of Mr. Lucky today.
Your name, sir? Are you here on this?
I am here on Inch, but I can go.
I need you to pull this file. All right, so defendant hasn't been here.
Yes, Your Honor.
We have multiple counts. He has 2 prior technical violations. He absconded. I have 6 counts. How's he going to proceed on these?
Your Honor, as I had indicated to you off the record, I was trying to get some more information as to the status of this file.
Well, the status is that he's blown us off for 3 years.
Right.
That's the status. I sentenced him May the 12th of 22. I don't know what else to tell you.
Well,
You can, no.
Okay.
Hang on. You can look at the probation violations. He's got 6 of them. They think he didn't attend his probation visit on October 13, that he didn't attend the court work program on October 5 of 22, that he didn't provide proof of completing 4 hours community service by October 10 of 22. He didn't even provide verification of attending and completing outpatient treatment. That he failed to refrain from consuming alcohol and controlled substance, testing positive for marijuana and alcohol back at a chemical test back on September 13 of 22. I don't know what else to tell you. I mean, you can look at the file. He pled to impaired.
Your Honor, May I address you now?
No, you look at the file. I'm gonna only do this in one way. I don't do Cobb's pleas.
Okay,
He's got a big problem with me.
all right.
He's blown off the court for 3 years, and I don't appreciate it. So
We have,
I know, he was running the Pentagon. I don't know what to tell you, seriously. I don't want to hear these excuses. He knows that I know if I told him I'd give him $5,000, he'd have been here 3 years ago.
Give me a chance to.
Yeah, take your time, but I don't get it. I just don't get some of these guys. I really don't. They just, guys and gals, think they don't have to show up for 3 years and then come in and pretend like it didn't happen.
He's not a bad.
Oh, I'm sure he's not. None of them are. Anybody who ignores a court for 3 years is about as respectful as, that's the way I feel about it. You can come back and prove to me I've been thinking wrong for 60 years. William Michael James, 23B726981. I need Mr. Crawford. If we got to give other things to other lawyers, but I got him with Mr. Inch, right?
Mazin is with, Mr. Inch.
These poor guys been waiting around and I can't get them in here.
Mr. Mazin said to me.
No, not Mr. Mazin. I'm talking about Mr. Crawford's got him. So you can leave.
Okay.
Come back with Mazin, Gaith, and Inch, and you can come back on the other one.
Mr. Gates said to me as he left, that he was gonna join for Mr. Inch on Zoom because something in custody, but I was.
Mr. Inch is right there.
No,
I have MDOC here that needs to be handled before we lose them.
Okay, go ahead.
Arraignment.
What you said.
All right, so William Michael James, 23B726981. Your name, sir?
William James. Like you'll cross the representative.
All right. Before we go on, I'll just indicate that defendant has been on bond conditions. And we're going to accept them. So have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
I have had the opportunity to review the report with my clients, and there are no material additions or deletions. We asked the court about the recommendations presented.
Anything that you would like to say on his behalf?
No, sir.
And you're done?
No, Your Honor.
Sir, I'm gonna be glad to take you, but you missed the test. We talked about its status review this morning.
Yes, sir.
Can't miss me.
I know.
I'm gonna let it go. I'm not gonna let it go next time.
Okay. I'm sorry about that.
Well, why'd you miss?
I overslept my alarm. And I woke up at 9:50.
You have an alarm clock?
Yeah, I used my phone.
Well, then how did it not go off?
I swear I was mad at myself for missing it.
The phone was defective? Is the phone defective? Did you set your alarm?
I set like 10 alarms. I set
10 alarms? None of them went off?
I'm a heavy sleeper. so I accidentally
You
missed
should
them.
buy a lottery ticket.
Yeah.
I mean, if you turned 10 alarms on and none of them came on.
I think they came on, but I think I slept on my phone, so that probably had something to do with this. I didn't hear it.
All right, now wait a second. You're making this worse. You set 10 alarms.
Yeah.
Either none of them went off, or all of them went off, or any combination thereof went off, and you slept through it?
Yes, sir.
Come on. What are you, Rip Van Winkle? I mean, come on. I mean, you got to make sure this doesn't happen. Who do you live with again?
My parents.
Well, then you have them come wake you up.
My mom's over.
I saw her. She raised her hand. Don't miss again.
I won't, I promise.
There is nothing I find amusing about this. 2 years probation. Be glad to take you. But that worries me. You cannot leave the state without the consent of the court or violate any law. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana either. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing on demand of probation. They're going to tell you when you have to go. At least I'm going to need his ownership record on this, please. No alcohol, no marijuana, no illegal drugs. Chemical testing on demand, submit the PBTs ETGs and chemical testing on demand of probation, complete 60 more days on the sober link, but we are going to switch that into our name, so we're paying the bill with our grant. Attend 12-step meetings 3 times a week and provide proof, obtain an AA sponsor, attend all substance abuse treatment, attend the Victims Impact Panel, attend and complete the Armed Specialty Program, report to sobriety court status reviews with me every other week, obtain and maintain employment with proof provided to the probation officer. Do you own that vehicle that was being operated on the date of that?
I do not, sir. That was my father's.
What do you mean was your father's?
It is my father's. Sorry.
Okay. Seven days jail, credit 1, serve 6. I'll let you serve those as follows. You're doing well on this. Otherwise, serve 4 on the court work program, 2 days of community service. I'm going to give you until August work 1st to complete your 16 hours of community service. 4 days court work program, pay $105 for that. I'm sorry, $140 for that, $35 a day. Fines, fines $200, costs $300, 75 victims' rights fee, $50 justice assessment. So fines and costs are $6.25. Screening fees $60 for $685. You have probation fees of $360, bring your total to $1,045, $480 in probation fees. That brings it to $1,525 plus your court work program fees. Your total is $1,625. If you violate, your probation could be revoked. You could be incarcerated for 93 days with credit for 1 day served. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, sir.
Lisa, did you run that ownership?
Yep, give me 1 second. I have to grab it off the printer.
Take your time. So I would have to order your vehicle immobilized, but if you don't own it, I'm not ordering it. You didn't own it at the time of the accident. I'm sorry, at the time of the incident. All right. Does he have all this to pay?
No, Your Honor.
How much does he have today?
400.
Okay. All right.
Judge, it's registered to a Brian and Brittany Janes.
That's my sister and my father.
You pay $400 now. You are making $750 a week, gross or net, before or after tax?
That's after.
Who's is Tricia James? Is this your mother? Is she going to let you apply the bond or not? If you don't want to, you don't have to.
I'll apply the bond.
That's 5,000, 10%, I believe, Lisa's. Or was it 3? Let me see. I don't know if it's 5,000, 10% or 5,000 or 500 cash. But anyway, we're going to say he pays $850 now. And then balance at the rate of, can you pay 50 a week? Balance at rate of 50 per week. I'll start that beginning on June the 21st, okay? If you need more time, no problem, call the court, we'll go on Zoom. I'll be glad to give you an extension. Any questions?
So today I just pay
$850.
$850.
You're going to pay, you're going to sign over the bond. I don't have proof here right now as to whether or not it's 5,000, 10% or 500 cash.
It was a 10%, Judge.
So you have $450 plus your $450. I just made it $850. You want to pay the other $50, you can. Okay? And then you'll meet with probation. I wish you well. I hope we help you. Good luck.
Thank you.
Don't miss again. Make sure he gets the testing. Darren Joseph Gazabon, 25B147802.
Good morning, I'm Michael Crawford, representing Mr. Gazabon.
Mr. Gazabon, your name?
Darren Joseph.
Well, if anybody I've had today deserves to go to jail, I hate to give you the bad news. It's you. Have you had a chance to review the report with him?
I have, Your Honor. There are no material additions or deletions we've had on the clients. We need to comply. We look forward Sobriety.
Mr. Casabon, what can you tell me?
Well, Your Honor, when this all started, about a month ago, I was having a problem with it. I'd already do some self-checking and, this past month, honestly, I'm in a 36. My life has changed and I'm looking forward to doing whatever I need to do and growing.
Mom, come on up here a second. I hate to do this. He's old enough. He's going to be 40 years old pretty soon, right? I mean, you're 38, right?
Yes, sir. Mr. 38.
You're going to die if you keep on this.
I'm experiencing health issues from using it as, they're kind of.
I don't want you to have to go into that. How you doing, ma'am? What's your name? Deborah what? What can you tell me? You noticing a difference here?
Absolutely. I can tell you.
I scared her.
I'm sorry.
I think I scared her.
Well, I think it scares me. It's just uncomfortable, but it's right. And we were never against, the consequences of the bad decisions when he was younger. And just, watch the struggle. And it's been a struggle for all of us to watch, but I can tell you since he's been out, it's been a year and a half almost. It's been different, it's been totally different now, little blips, yes, couple little blips. Friends are going away and that's been a great thing. So getting rid of the old friends, the people that you think are okay. So now, since this, has it been?
The good news is this wasn't assaultive and it was not a drunk driving. It was loitering where drugs are present. I know he struggles with it. It's evident to me he's been struggling with it pretty much his whole life, going back to 05. I mean, it was just marijuana, then impaired 08, analogs 08. He's got larceny of buildings, retail frauds. He's got all these addictions. He's got all these ugly convictions on here. And I'm sorry, I cut you off.
Well, no, I wanna thank you.
You don't have to thank me. You would thank him because this makes parents get old. You're done with this. I'm telling you, I'll be your best friend if you stay clean. If you don't, I'm going to turn on you like you can't believe, because honestly and truly, I will go home tonight and wonder why I did not send you to jail.
I can show you. I can do this.
2 years probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you have to notify probation. No alcohol. No marijuana, no illegal drugs, none of them. Not to purchase, possess, or consume any. Submit to chemical testing on demand to probation. Submit to PBTs, ETGs, and chemical testing. Even though you're not drinking, it doesn't sound like, you're still going to go through 60 days on the sober link from today. You're to attend AA meetings at least 3 times per week. You're to obtain an AANA sponsor, attend all substance abuse treatment, attend the Victims Impact Panel, attend and complete the Armed Specialty Court Work Program, report to sobriety court status with reviews with me every 2 weeks, obtain and maintain employment with proof provided. You don't have any health issues to prevent you from working on the work program, right?
No, sir.
100 fines, 100 costs. This is, again, I'm going to keep in mind, this is not a drunk driving or an assaultive. 100 fines, 100 costs, 75 victim charge, $50 justice assessment, 3 1/4. Screening fees, 60 for 385. Probation fees are 480. So your total is 865 plus 1245. 316 sobriety court fees at 1245. And I got to tell you, the court work program fees you're to clear all warrants within 30 days of sentencing. You're going to do 10 days on the court work program, and you're gonna pay $35 for that, for a total of $350.
So I pay that when I go there, or that's just all of it?
That's all included.
Okay.
So Lisa, what did I said before that? I forgot what number I had.
I'm at 1575 with the court work program.
100, 200, let me just double check that. Not that you wouldn't completely get it right. 385, 685, 745, 1145, 1225. Okay, I better do it again. I got 1575. Let me double check. 200.
That's what I said, 1575.
Oh, okay. Thank you. All right, so 1575, I hate to do that, but if you violate 90 days, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer. Do you understand one another?
I do.
Stay with me.
I'm going to.
You seem like a nice kid, but you gotta stop the drugs. Okay? We're gonna help you.
I believe it.
Okay, ma'am, thanks for coming. You show up at sobriety court status reviews with him. That's fantastic.
I'm supportive of all this.
Of course. Well, he's gonna be a different person. If he just stays with us, he's gonna be a different person. Payment.
Your Honor, my client got $100 today. If you stop that.
He does have 100, or
He's got $100.
pay 100 now, and then how much can you afford to pay?
50 a week work.
I'll tell you what, you do it however you want. I'll make it 100 now, 100 bi-weekly, and I'll start that beginning June the 21st, okay? If you need more time, no problem, call the court, we'll go on Zoom, or you can come in here on or before the due date, 8:30, you'll meet with the probation. Sincerely wish you well. Good luck. Thank you. Thanks for coming, ma'am. Alger Ivory Pierre Lucky, 222-139-7938. I don't think I have any more of yours, do I, Mr. Crawford?
Yeah, you got one more. I've got two more.
Okay, go ahead. Go deal with them, and I'm gonna take this one and Mr. Inch.
Thank you, Your Honor.
All right, I need Beth Wiles.
For the record again, Kimberly Bell, P447111, I appear on behalf of Mr.
Good
Lucky.
morning again. Your name, sir?
Alger Lucky.
All right, so he has, have you had a chance to review this file?
I did.
What is he going to do? Is he going to plead, or does he want a hearing on these 6 counts?
No. He will please.
So, sir, if you plead guilty here, I want you to understand your probation could be revoked and you could be incarcerated for 93 days. Do you understand that? And did he sign an advice of rights form today?
He did not, Your Honor.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. If you remain silent, that silence would not be held against you. Do you understand that?
Yes.
If you plead guilty, you're waiving your right to a contested hearing, you're waiving your right to a hearing of any kind, and you could be incarcerated, as I said. And again, you have 2 priors, technical violations, it says. But given that you have absconded, you could get the maximum. Do you understand that?
Yes.
Any questions before we go on?
Your Honor, best with Judge Hudson.
Okay. Any questions before we go on?
He's not on Zoom. Amazing. He's in custody.
No questions, Your
All right, as to count 1 that you failed to attend your scheduled visit on October 13 with probation of 22, how do you plead?
Yes.
You failed to attend your probation visit on that date.
Yes.
Count 2 that you failed to attend the court work program on October 5 of 22, how do you plead?
Yes.
You failed to attend on that day.
I showed up, but I had on shorts and I forgot that you can wear shorts and sent me on.
Count 3 that you failed to provide proof of completing 4 hours of community service by October 10 of 22, how do you plead?
Yes.
Did you fail to do that?
That's community service. On my last day, I had community service, but I forgot I couldn't wear shorts.
You did 3 days.
Community service is different than court work. You would have set up your own community service.
I don't think, we were talking about this, Your Honor. I don't think he understands the court work program.
It's not considered community service. It is community service, but it's supervised court work.
All right.
So I ordered you to do 4 more hours of community service at some point, and I'm just asking you, did you complete the 4 hours of community service by the due date of October the 10th of 22?
He completed 3
No,
days.
no, that's a court work program.
Oh, you're talking about court.
I sanctioned him at one point in August 31 of 22 in order to complete 4 hours of community service by October 10. So the charge is that he failed to provide proof of completing that by October 10. So how do you plead to that?
Really?
The community.
Why are you confused?
Yeah, not guilty.
Did you fail to provide proof of completing community service hours that you were due to do?
I have 4 more left. I have 4 more hours left. That they sent me home. That was my last day of community service.
That's the court work program. I don't know how many times I gotta tell you that. When we're supervising, when you're showing up at this building, that's the court work program. That's where it's a little bit more stringent. I allowed you to do community service where you could go fold clothes somewhere at the Salvation Army or do something else by October 10th.
I can't do it.
He did not, that's the court work program. Are you listening to me?
That's where they sent me home from.
But he said that they sent you home from the court work program.
That's not community service.
Oh, my bad.
You could have done community service at Salvation Army, St. Vincent de Paul, a church, Habitat for Humanity, an animal shelter. You could have done it wherever you wanted. You could have done it.
Oh, so I had it confused. I'm sorry.
Oh, yeah, that's all right.
Yeah.
But so I'm gonna ask you again, did you fail to complete that by October 10 of 22? You didn't do it, right? Count 5, that you failed to refrain from consuming alcohol, testing positive on September 13 of 22 for both alcohol, that's on count 5. How do you plead to that?
Guilty.
And count 6, marijuana. How do you plead to that?
Guilty.
Anybody, did you consume alcohol and drugs, marijuana within the 3 days before September 13?
Yeah.
Anybody force you to plead guilty?
No.
Pleas are accepted to those charges. You got 6 counts. I can't wait to hear what the explanation is. I have a feeling I'm not gonna like it because it's gonna be he didn't have a ride or he forgot or.
Your Honor, I would just very much appreciate it if you at least let me explain something.
Oh, no, you explain all of it. Take your time, have at it.
First of all, that was in 2022. This is 2025. Mr. Lucky's in a completely different position in terms of where he is with this case. He wants to take care of all of this and meet his responsibilities under this case. Him not showing up, he moved to Ohio.
Did he get permission to leave the state?
I know where to live in Detroit.
I'm just asking you, did you get permission from anybody to leave the state?
No, you said I can go to work, because I work now. You said I can,
I didn't say you could live there though, did I?
No, I ain't had no choice.
I said you can leave state for employment, but go ahead. So he violated probation in that aspect too, but go ahead.
Okay, so, he was in Ohio, and because this is based on the OWI charge, his license was revoked, so he didn't have transportation up here. Now he does.
How many drunk drivings does he have?
Just one.
They didn't revoke him there.
Oh, no.
They
Never had. No, I was trying to leave my license when I ended up catching I was just paying my tickets off. When I ended up catching tickets last time.
Okay, go ahead, counsel.
Okay, so anyway, now he has access to transportation with his brother. Secondly, Your Honor, again, he moved to Ohio.
Whereabouts in Ohio?
Toledo.
This was a second drunk driving, right? Or at least he didn't appear to see. He had one in 15.
I thought this was the only one, Your Honor.
Well, maybe he still has that warrant out. Let me double check out of Dearborn.
I had a warrant.
Go ahead, counsel, I'm listening to you.
Okay. So anyway, because he was in Ohio, that prevented him from coming. He didn't have to, well.
Where's he live in Ohio?
This is what I have to offer.
Where's he live in Ohio?
He's living in Toledo.
Come on.
So now through his brother, which he didn't have that transportation before, he has transportation now. He can get to his scheduled appointments. He can get to whatever programs and whatever he has to do. He's also able to pay all of his probation fees. And I would just ask Your Honor to consider all that. Like I said, he's not the same guy that he was in 2000.
Well, you're not giving me any reason to tell me he's changed, other than the fact that he moved to Ohio and couldn't get here from Toledo, which is
Well,
only
what
4.
has changed, I should say, not necessarily, I can't speak about him, but what has changed is that he has transportation. He has access to some.
Where does he work?
He was working at the Chrysler plant and then got laid off.
When did he get, what Chrysler plant?
Toledo.
When did you get laid off?
January.
How long are you working there?
2017.
Did somebody call Beth on this?
I'm not sure if John did, Judge, but I'll call her now.
Well, he did say she was in Judge Hesson's. I don't know if she still is. Can you tell by looking out there, Lisa, is she still in Judge Hesson's?
I can't see her courtroom, Judge.
Okay. All right, go ahead.
So anyway, for all of these reasons, I'm asking you to give my client another chance.
No, I just don't,
And
I'm telling you the way, to me, there's no stay of the probationary period. He's been gone for 3 years. I really, as far as I'm concerned, I lose jurisdiction after today. I mean, there's nothing I can do when they do this. That's why it's upsetting.
I understand.
He doesn't show up here. We know what happened. He tested positive. He got scared or unconcerned. He didn't do anything. He had 2 violations within the first 3 months.
But that's exactly what happened, Your Honor. He got scared. When he moved to Ohio and wasn't making his probation meetings, he felt that he was already in violation.
Well, yeah.
And I know the thing to do, or what the thing he should have done, was to call someone to tell them what his situation was. But we deal with real people. And,
Do you have kids? You married?
I got 3 kids, and that was a whole accident.
Where were your kids at?
At school right now.
No. Where were they in 22, 23?
At 22, we was all together. We was all living together after the accident.
Slow down.
Yeah.
How old are your kids?
I got a 19-year-old, now a 16-year-old, and a 12-year-old.
They all moved to Toledo with you?
No.
They stayed in Detroit?
Yes. Me and my lady split up after the accident in one car. It really took.
he had an accident, Your Honor.
The thing, that's what I'm talking about. It really messed up my whole life. I had the phone, my old number with all your contacts in it. She broke the phone, I couldn't get in the iCloud.
Just to put some context to this, on this OWI charge, there was a truck that hit him. And it kind of dominoed from there. And that's what he's trying to explain.
How old are you?
40.
You got laid off from Chrysler, Jeep plant in what month? January?
Yeah, yes.
Is that a permanent layoff or is that?
Yeah, because I didn't take the full time. I had turned it down and I got pushed it back to the back. So now I'm on like what do they call it? TS or like a TPT. So I might, they might call me for the summer. I might.
Oh, you're a temporary employee?
Yeah.
Who do you live with now?
Homegirl.
Pardon?
One of my friends. She's my friend, right? I would say my girlfriend.
Well, that's all right. I don't need to get detailed. I just wondered where you're traveling about. You left your brothers then, right?
Do I leave my brothers?
Yeah.
No, I don't stay with my brother. He just,
I thought you said it did, maybe I misunderstood you. Did you tell me or did you not tell me that you went to live with your brother in Ohio? Did I
stayed
misunderstand?
in Ohio. I stayed with my uncle in Ohio. When I left my family in 2022, I went to Ohio and stayed out there in Ohio. Was going to work
With who?
out there.
With who?
My homegirl.
I don't know.
Girlfriend?
I said my girlfriend. I said my girl.
Ms. Wild's your name?
Elizabeth Watch Fiction.
Can you give me any good news on this one?
I think the only bit of good news that I can give to you on Mr. Lucky is he did complete his victims impact panel. Other than that, unfortunately, it's kind of complete abscondment after he had missed his appointment October 13th. And even the 4 hours of community service was part of penalty from a prior violation. He didn't need to complete those 4 hours of community service. I wish I had better things to say, but he just basically up and left and we didn't hear from him again.
And like I said, Your Honor, that's because of transportation issue. It's because he should have called, he should have let the probation officer know. However, he didn't do that, and he's in this situation now.
I mean, he just ignored us and ignored us here. I'm looking at this. It's like, seriously?
But you know what people do, Your Honor? When
Listen,
they think they're facing penalties in jail, thinking that they're.
I get it. I get it. I just still, yeah, I get it.
I can appreciate transportation issues, but he was reporting by Zoom, Your Honor.
And not only that, he didn't live in Cleveland. He's living in Toledo. I mean, if I'm going to say somebody that I'm going to excuse somebody for not having transportation that lives in Toledo, I've got to pretty much excuse anybody who lives north of, I don't know, north of 12 Mile Road practice. And then I'm just not prepared to do. He could have gotten here. He knows he could have gotten here.
He didn't have anybody to help him at that time. He's got his brother to help him now. And that was the problem. It was a problem getting here. It was a problem with having someone bring him here. And who he had is his brother.
You know, you're on the same page. I mean, I remember a justice writing something about, well, people don't have to get rides. Let's do it on Zoom. All I know, I don't say this very often. All I know is that anybody that comes here in this courthouse, there's only one of three things. They either live here, they drove here to commit the crime, right? Or they got a ride here. That's the only three things anybody could possibly come in front of me. They either here, they here, or they got a ride here. So I don't know what's so difficult about asking people that got a ride or drove here to get a ride here to pay the piper.
Right.
You know what I mean? So I'm trying to be understanding. I'm telling you, I'm not a fan of this. I never have been, and I never will be. I will do the best I can for him. How much do you have here, Lisa, in fees does he owe?
$884.
He will be able to pay that right away, Judge.
Does he have any credit coming other than the
The
one?
only credit I can say is we had scheduled for the work program. He was a no-show a few times. He wore shorts once, but he did complete at least one day of work program, which was August 3rd. So I would say he's got a day of credit for that, Your Honor.
Doesn't look, it looks like he had a warrant out of someplace in 2015, out of the Dearborn District for OWI. I don't see any disposition on that, either on his traffic record or on the criminal history. I don't know what happened with that.
Your Honor, I can't say this for certain, but I don't believe he was charged. This is because it's my understanding, this is his only charge.
Well, they issued a warrant for him on an OWI at one point, failure to appear in court back in 15.
I do have the screening assessment, obviously done at the time of his plea, Your Honor, 2012 out of 19th, he had failure to appear on drug and license suspended. 2015 out of Dearborn 19th for OWI and drug and license suspended. He also had 2019 out of 34th, but those were for civil infractions of speeding and no.
I'm not gonna take that into account. I was just mentioning that. If there's no evidence of a conviction, there's no evidence of a conviction. Probation is revoked. You're to pay costs of $950 and serve 93 days jail, credit 2, for a total of 91. If you pay costs of $950, I will suspend 72 of the 91, requiring you to only serve 19. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. So you pay that money now, you'll be out in 19 days with credit for time served. No.
I got one last issue, Judge. You're gonna be sick of me. But there was a court date scheduled for May, and he didn't get a notice and I didn't get a notice. I spoke to the clerk, Lisa. I submitted an appearance by internet. She said, no, the court never got an appearance from me. And the notice was sent to Mr. Lucky's former address on Braille in Detroit and not to his current address.
Well, how are we supposed to know?
I don't know. I did my part.
Well,
At least I thought.
But we don't have an appearance in the file until the one you filed on May the 15th.
Exactly, that's what she told me. And I don't know how that happened.
So I don't know.
Because the appearance I sent in, I didn't send it in to Lisa. I didn't write down who or where
So what are you asking?
Sorry?
I don't know what you're asking me.
Oh, if you would reinstate the bond. And that was.
There was a third-party bond posted, Judge.
Yeah.
And that would help pay.
I'm not gonna, I'll tell you what, if you want to, if you want to address this when he's out of jail, I don't have a problem. I don't even have a problem with you addressing it by Zoom, but there's too much for me to digest here. When people don't show up, I'm not gonna apologize. I don't like it. And
Can we get the bond? Can we at least apply?
I heard what you said. I understand, but he hasn't shown up for 3 years. I mean, what is this?
Okay.
What bond are you talking about? The one?
Judge, I can explain it. He posted a bond, so I set a court date. He did not appear because we had an old address. She states that she filed an appearance, but I never received it.
Is this a bond that he posted online on or about April 22nd?
Yes. Yes. So then when I heard from her questioning why she never got a date, she sent me a new appearance and I reset the court date.
I don't have a problem with reinstating the bond, but he's going to have to pay whatever else he paid because that's in the name of the third party poster. So the third party poster can come in here. We'll refund the money to the third party poster.
Okay.
Okay, I'll do that. I can see that at least he did that.
Thank you.
But he's going to have to pay his money today without the bond. And then he'll just have to serve those days that I gave him, which is after he pays the bond 19, or pays the fines and costs 19.
All right.
Stop doing this. Good luck. Have a seat. Thank you. People against.
You're welcome.
Tangeray.
Thank you.
Thank you very much. Nice to have you here. I want to do Inch as soon as I can get whoever his.
Yeah, Mr. Gates said he's going to do it on Zoom, Your Honor, because he's in, and he just unmuted and got himself on the screen.
Lisa, can you tell me whose lawyer Mr. Allen is?
It's Mr. Gates and Detective Cernas here.
Good, let's do that right now. Tangeray, and we'll get, Mr. Gates will do it.
You want me to wait, Judge?
You don't have to, just come on back in about 5 or 7 minutes.
No problem.
Tangeray Danielle Allen. 23W728-279 FY. Good morning,